attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Ronnie. Good morning and welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Judge Hand, and to my left is Judge Hodgens, and we'll be your panel for all 6 cases on our list this morning. For those of you who may not be familiar with the practice here in the Appeals Court, it's 15 minutes per side. There's no rebuttal. We've read your materials, we've read the cases, and so it might be prudent to get right to the heart of your arguments, but of course, the 15 minutes is yours to do with it what you will. And with that, we'll call our first case, which I'll remind the parties is partially impounded. It's in 25P0909 in the matter of a child. And I understand that the appellees will be splitting their time, 8 minutes, 4 minutes, and 3 minutes. You have the floor.
And if you're ready for me, may it please the court, I am Attorney Diana Spanos. I'm here today on behalf of the appellant guardian. Your Honors, this is the guardian's, primarily the guardian's interlocutory appeal regarding a very narrow issue of law. She's asking that this court interpret the amended statute, Chapter 190B, Section 5-212.
So just procedurally, you're going to be arguing, I think, in large part about whether or not she should be appointed counsel.
Yes.
Is that fair to say? And I read in the mother's brief that she also had leave to question whether or not this court has jurisdiction, Massachusetts has jurisdiction.
That's correct.
Over her matter. So why don't we begin with the jurisdiction question, right? Because if you don't have jurisdiction, then we can't appoint a lawyer.
May it please the court? Yes, I will. Essentially, the guardian contends that the child's home state has really been Massachusetts from the inception of the proceeding. The child's birth certificate is from Massachusetts. The child was born in Massachusetts.
If we disagree with you about that, and we thought that New Hampshire had home state jurisdiction, what would Massachusetts' jurisdiction be given the timeline here?
I'm sorry, I didn't.
If we thought that the home state for the child was New Hampshire, understanding that that's not your client's position, but if that's what we concluded, would Massachusetts have had jurisdiction at the time the guardianship petition was filed here?
The time Massachusetts, if I'm understanding your question.
Sure.
I would argue, yes. I think arguably New Hampshire took jurisdiction improperly.
Okay, but again, I'm saying if we concluded otherwise, if we thought that New Hampshire properly had jurisdiction at the time that it appointed the guardian as guardian of the child, same child, different state, would Massachusetts have been able to act as it did jurisdictionally under those circumstances?
I would say yes. I mean,
Okay.
if the court is not accepting the home state jurisdiction, then certainly under default jurisdiction, it would qualify because all of the significant information regarding this child was in Massachusetts, hospital records, information about the child's well-being. I believe that that warrants it. I think the New Hampshire court, in its own judgment, acknowledged that New Hampshire had no information regarding the child's needs or best interests. It was all located in Massachusetts, and that was primarily by the mother's desire. I mean, she maintained her health insurance there. She intended to have this child born there. She intended, to this date, continues to access, mass health and mass benefits. This is unlike the Farage case, where the mother made distinctive efforts to separate herself from Massachusetts. She relocated to Connecticut. She applied for benefits in Connecticut. She took classes in Connecticut. The mother did not do this here. And that, again, continues to date.
What do you say about the argument that this is really kind of classic forum shopping, where a court takes action in New Hampshire, days later, perhaps dissatisfied with the pretty much open windows of visitation, the guardian comes back to Massachusetts to try to get a better arrangement from a Massachusetts court.
I think I would respond with kind of the same answer. This is where Massachusetts holds all of the information regarding this child, and there's no reason to suggest that, I mean, given the facts, mother still doesn't have any health insurance or
How was it that the great aunt became a temporary guardian, and where did that take place?
it took place in Massachusetts. The mother requested that she take custody of him on March 11th, and on April 8th, and this is according to the New Hampshire judge, when the mother failed to appear to pick him up, you know, she applied for guardianship. And she had legitimate concerns about what she was observing regarding the mother's care of the child.
Judge, who?
I'm sorry?
Who are you referring to?
The guardian.
Guardian.
The guardian had legitimate concerns, the way she was holding the baby, the frustrations that she was observing that the mother and father were both having. She had legitimate concerns. And when they dropped off the child and then didn't come back to pick him up, without a lawyer, without the benefit of legal advice, she drove to New Hampshire and applied. And then she came back and, you know, I mean, my colleagues have a different view of this, but she lives in Massachusetts, and this child was going to appointments on a regular basis. All of that information, all of the child's primary caretakers were located in Massachusetts. The New Hampshire court acknowledged that.
I'm not sure that this matters particularly, but did did the guardian in her New Hampshire petition list her own address as being in New Hampshire at some point and indicate that she had cared for the child exclusively in New Hampshire?
Did the guardian list the mother's address?
No, her own.
No, the guardian has always lived in Massachusetts. No, and again, I mean, the mother's intent was to find housing in Massachusetts. So, I mean, at best, maybe the mother's address was a temporary location. Notwithstanding that, and all potential fraud aside, these parents have both maintained legal Massachusetts addresses where they collect benefits, where they receive services, and that's done intentionally. And so to get back to the original question, the guardian does argue that Massachusetts is this child's home state and was from the date of his birth.
And is all of the information that you're referring to about the parents' maintenance of Massachusetts legal ties included in our record?
Yes, I mean, actually, I know there was some contention, but the voluntary acknowledgement of paternity that was just recently signed in January of this year, both parents list their Massachusetts address.
But I guess what I'm asking is I'm trying to just think through all of the possibilities. If we were to conclude that there was a question that about home state jurisdiction, do we have what we need in the record as far as what the facts were at the time that the guardianships were obtained, not after that fact?
I think I understand
or
what you're saying.
Is it something we would need to remand to have additional proceedings?
It is true. The benefit would have been if the two courts had conferred, and they didn't. But if I refer to custody of bail, this court did request documents from the state of Indiana, specifically because the judge didn't have all of the relevant information at the time that the judge made that decision. And so the appeals court reached out and got records from another state. And I think had there been a hearing, a lot of evidence could have come in regarding the child's medical needs and the amount of time that the child was receiving services in Massachusetts prior to the New Hampshire order issuing, if that answers.
It does, thank you.
Okay. And if I can now move on to the second, issue, if the court would indulge me, I'd like to sort of walk through the statute with you. It involves the resignation, removal, and other post-appointment proceedings. So when the legislature got together and amended this statute, arguably on its face, they were looking at the amount of time that a guardian has had the child, and pinpointing anything greater than 2 years is, and should be entitled to counsel. The trial judge considered that this was a petition to appoint a guardian and not a petition to remove one, so he felt that this didn't comply with the guardian's request for counsel, and he actually found no case law to support it, and that's why I think it's really important that this court really interpret and answer that question.
Do you think that that's accurate, that this is not technically a removal case?
I believe this is a removal case, and if you look, first of all, guardian, as defined under General Law, Chapter 190B, Section 5-101, is inclusive of temporary guardians. And I hesitate a little bit to go out on a limb, but I have looked through this statute pretty fully, and I don't see the word permanent guardian really used. And I would argue that it's more of a colloquialism or slang that we as practitioners use to talk about things pre-trial and post-trial.
Is there such a thing as is a temporary guardian a term used more specifically than the permanent guardian?
Yes, absolutely.
Right, and
the
is
legislature recognizes a temporary guardian. I don't see evidence that the legislature differentiates at all regarding a permanent guardian. And honestly, if you look and compare the circumstances, when DCF takes emergency temporary custody, and then after a while they get permanent custody, their obligations and responsibilities to that child don't change.
Is there a presumption in the temporary guardianship that it is of a limited duration?
Yes, and
Is that true of it's not?
even in the standing order, the case should not linger this long.
But it's a 90, am I understanding correctly that it's a 90-day appointment?
90 days, and then you're supposed to come back for a hearing if there's been proper notice, and then the court's supposed to make a decision.
Right, and then the burden is on the guardian to establish a basis for continuing the
burden
temporary
is on the
guardianship?
guardian, correct.
Is that the same in the case of a guardianship that is not temporary? Once a person is
No.
appointed as a guardian, is
No.
the presumption that that stays in place until there is unless and until there is an effort to remove that person or the person resigns?
That's
Okay.
my understanding. And the other hang-up, and I apologize to the court because as much as I've looked at this statute, it didn't jump out at me until I was preparing for case, but the word petition, which I think has been a hang-up for the judge, and again, we as practitioners, petition is defined by the statute, is a written request to the court for an order after notice. So arguably, when a mother files or a parent files an objection after even a temporary guardianship opens, and in this case, she filed an objection, she also filed a motion to vacate, she requested filed an emergency for return of custody. Petition, as defined by the statute, includes this. It's not, again, I think we as practitioners have gotten it that a complaint for divorce initiates that proceeding, or a petition for something initiates a proceeding. The legislature doesn't view it that way.
Yes, but isn't there, there's something fundamentally different, though, about removing, an effort to remove a guardian versus an effort by a guardian to be put in place, right? One is defensive, one is offensive. So I can see the logic behind the legislature saying, yes, if action is being taken against you as a guardian, you should have a lawyer. But I don't really see the logic of saying that a guardian, someone seeking to become a guardian in an offensive action, so to speak, should
If
be
I
appointed an
understand
attorney.
correctly, I think the 2-year time period is what the legislature was focusing on, because I think there's a given reality that temporary guardianships, frankly, last too long. It's really not fair, and I'm not blaming a trial judge, because as a practitioner, I know how things get delayed and they get pushed back, and there are multiple issues that occur. But after 2 years, I think the legislature said, wait a second, this is, we're looking at the welfare of the child and the well-being of the child, and the legislature has recognized that 2 years is a significant period of time. And I think the fact that the statute actually also includes time period before the guardianship even entered. So if the parent, or if the guardian was caring for the child before he or she took any steps to obtain guardianship, that counts towards that time period. And that is a recognition by our legislature that it's important and needs to be recognized. And I think in comparison to guardianship of KN, for example, where the court also recognized the benefit of having counsel for a guardian, but stopped short of that and said it's the probate court should have equitable authority to gain that. This statute takes that discretion out. And I think that's right. I think arguably the right to counsel is such an important issue that to rely upon any court's discretion is going to end up with inequities and unfairness, because we all know that some judges are much more fiscally aware and worried about budgets. And for example, CPCS, when guardianship of KN entered, CPCS took the position that if the probate judge is using his discretion to appoint counsel, then that should come out of the probate court budget. But if it's a statutory right, then CPCS picks that up. And I just think, again, it's too important of an issue to allow that to be the discretion of a trial judge. You are going to have inequities statewide.
Anything additional? I see that's your time, Attorney Spanios.
Thank you.
Thank
I
you.
will rest on my brief.
Thank you. Attorney Barrow?
Oh, good morning, Justices. I'm Deborah Barrow, and I'm here representing the mother, and she's watching us today on YouTube. And I just want to start out, there are two issues before the court. You've identified them.
Move that mic down
Sure.
a little to you. Thank you.
And let me just tell you that I do have some hearing loss, and I have hearing aids, but sometimes the ventilation will interfere, so if I ask you to repeat, I apologize.
Now that
in
you've moved it
advance.
down, can you move over to it?
I'm sorry. Okay. But yes, there are the two issues, and I'm going to give you some focus, hopefully, on the subject matter jurisdiction, and I am prepared to address somewhat the denial of court-appointed counsel. But I think that my two stellar colleagues here have spent more time with that issue, and so I'm going to, and that's how we split our time, just to give you a roadmap of how we anticipated the proceeding. So yes, as noted, there are two issues here on interlocutory appeal. And the first raised was the denial of court-appointed counsel. And in the process of briefing that, I came across information that was not actually contained entirely in the record appendix initially, but I found from the trial court, and I found from my client, and there were documents that were external to what was originally presented. And reviewing that and having conversation with other counsel and trial counsel, decide to proceed and present the motion to the court.
Does your argument on jurisdiction rely on material that is outside the record that was provided to the judge who decided the motion to vacate?
No, the decision to brief this and to present today is relying entirely on the information that is presented in the supplemental record appendix. And I think that duplicated in some measure what Attorney Spanos provided in the original record appendix. There may be some items that I did not include, but I believe those were trial court items. So there's nothing outside of the record that I am relying on. I'm aware that there's other information outside of the record. But yes, so let's start with that. And I'd like to frame the question so that we're all focused in the same place. And I would suggest to the court that the question is not, as the temporary guardian is suggesting, whether Massachusetts had home state jurisdiction in April of 2022. As a result, New Hampshire should have declined jurisdiction in March of 2022. The question really is whether New Hampshire, consistent with the principles found in the MCCJA, Mass Child Custody Jurisdiction Act, and the PKPA, the Prevention Kidnapping Protection Act. I'm sorry, so I always get that wrong. But the PKPA and the UCCJEA, which is Uniform Child Custody Jurisdiction and Enforcement Act, whether New Hampshire, consistent with these statutes, properly assumes subject matter jurisdiction in the guardianship of minor case filed in New Hampshire by the temporary guardian in March of 2022, and whether the exercise of that jurisdiction was exclusive and continuing at the time the Mass Court appointed the temporary guardian.
Do you agree that this is, with your Attorney Spaniels, that this is a removal case?
I'm sorry, I didn't hear the.
Do you agree that this is a removal case?
With respect to that issue in terms of this case, no, I disagree with that.
Why?
I disagree with that because in the Massachusetts, well, for a number of reasons. First, I would argue that the Massachusetts court didn't have subject matter jurisdiction, and so it had no authority to enter any order, and the very first order that it entered was void ab initio, and the extension of that temporary order, every single extension was void as it entered, and so that court having no jurisdiction, none of those orders were particular. So they have no authority to appoint anybody to anything in my frame of reference, in my world. So no, I don't agree this is a removal case. But and so I don't know that it's necessarily. Well, I don't know whether if you would agree that there's no subject matter jurisdiction, whether you would want to hear more on that issue, because it's one of those issues that might be moot, but capable of repetition and evading review. So you would have that authority to do that. But no, it was not a removal case for that reason. And I would suggest to you to argue on that basis that it's not a removal case at all. The statute is a statute, and according to Massachusetts case law, it's strictly interpreted. And I would draw the court's attention separately to the recent case, which is CPCS versus Middlesex and Suffolk County District Courts, where the SJC in multiple versions of that, dating back to, I think, starting 2020, but 2025, where it was Carasquillo, I think it's referred to, and I'm probably pronounced that incorrectly. But the court is focusing the SJC is focusing on, does the court, does the appeals court, does any court in Massachusetts, the SJC, have the authority to expand a class of potentially, a person's entitled to counsel, because it's going to have an impact. And if it's a significant enough financial impact, is what I'm talking about, then it gets into that separation of powers issue. And the SJC most recently did say that they were not going to expand agree to expand the court's authority to increase the rate of pay for the private bar advocates, because that's what CPCS was asking SJC. Someone take a hold of this and increase the rate of compensation for the attorneys. And the SJC, recognizing the validity of the request and the need, but also recognizing the demand for attorneys and the backup with representation, said we don't take that step. We don't go further, because we're now starting to encroach upon the legislative branch. And so I would present to the court that there's consideration to be given in terms of any type of decision about construing a statute to provide more protection for people, which is really worthy and deserving of merit. And I know that there are arguments that suggest that strong arguments that suggest that this is not the approach to take because of the financial consequences that can flow. I'd like to answer any questions you may have about subject matter jurisdiction. If I could just turn back to that, I'm running out of time. But I would like to just point to the court that you had asked the question before in terms of, is there information that's not available, on the record on which statements have been made or perhaps conclusions drawn. And I would suggest to you that there are pieces of information. Like, I don't think that Massachusetts driver's licenses, the alleged Massachusetts driver's licenses, are on the record. I believe the birth certificate is, and I know the voluntary acknowledgement is. But that was dated in 2026. So any argument pertaining to that document as evidence of something that we're looking at in 2022 is really not relevant. And I would point out generally to the court that there's another statement that, sort of a chronology that troubles me, and I'd like to just reiterate for the court that it was the parents and the temporary guardian agreed that the temporary guardian would take care of the child from March 11th of 2022 to April 8th of 2022.
Are you basing that on the New Hampshire judge's findings?
The New Hampshire, pardon me?
Are you basing that on the New Hampshire judge's findings when the petition was granted, or is there some other basis for that finite
The
period?
basis for that finding is in the New Hampshire judge's finding, and I would have to go back and look at there's other parts of the trial court record where that may have been introduced in an affidavit, so I can't exclude that. But this time frame is really critical because the temporary guardian is arguing that the only reason that she went and filed for the guardianship, not the only, but one of the main reasons that she filed for the guardianship was because the mother and father failed to pick up their child on April 8th of 2022. And that triggered her to go to court. But she had gone to court on March 16th, and she had a temporary order in New Hampshire by March 17th. So I ask you to look carefully, and I am run out of time, but I could give you a quick list of the inconsistencies, lack of sight to record evidence, lack of legal authority.
Why do you object to the guardian getting appointment of counsel? Why do you object to that?
Why do I object to that?
Yes.
I object to that on many reasons, because I believe that in a procedural context, I believe that which is not having to do with the child or the parents, but I believe in a procedural context that the temporary guardian was manipulating the court system. She was forum shopping. And I think that's most evidence when you see that she got an order from the New Hampshire court on April, it was 24th or 25th of 2022, that granted liberal visitation, appointed her as guardian, and ordered a review date in 90 days and indicated that the court was likely to return custody to the parents. The next thing she did was go to Massachusetts and try to file an emergency request for temporary guardianship in Massachusetts, which the Massachusetts court denied on April 25th. I'm sorry, she got her judgment April 19th in New Hampshire. She went to court April 25th, I believe it was, in Massachusetts. They denied her request, saying no emergency exists, right? That New Hampshire guardianship protections in place. That afternoon, because you can see the timestamps on the documents, that afternoon, that same afternoon after she had been in Massachusetts, she filed another motion in New Hampshire asking the New Hampshire court to revise its visitation order.
This is a child with significant special needs. Is that fair to say?
No, it's not fair to say, because there's nothing in the underlying record that indicates what those needs may be. And while the New Hampshire court, in the findings on April 19th of 2022, did say that everybody agrees that the child has some special medical needs, it says there's no clarity on that point. And there's been no clarity to date. There are no records in the trial court that I know of that have been produced, or at least available to see, to explain that. No educational records. There's nothing. And access to that information, well, that's off the record. It's just been denied. But there's no information that's available to assist people who are trying to assist the family, the mother, the father, and in particular, the child. And the temporary guardian should not be the permanent guardian, because every single step she has taken has been to deny this child and its parents visits.
Did she become the temporary guardian in part at the request of the mother?
I'm sorry,
Did she become the temporary guardian in part at the request of the mother?
No, because it's on the information that I have, and looking at all the pleadings and looking at the time frame again, Justice Desmond, is that they had an agreement where the temporary guardian was not the temporary guardian then, back right on March 11th, Mom and Dad were taking the child to Massachusetts to stay with the temporary guardian, and until April 8th. The temporary guardian went to court on March, 5 days later, on March 16th in New Hampshire, to get a temporary guardianship. If you look at the paperwork, she filled out that, I think she requested, I can't remember if it's at that time or maybe it was in Massachusetts, but she was requesting benefits in terms of WIC and other financial support. So I don't know if that answered your question, because I've walked myself right away from it. I apologize.
I see that's your time. Thank you very much, Attorney Brown.
Thank you very much for the questions and for listening, and thinking about the kid and the parents.
Attorney Cantor?
May it please the court, my name is Andrew Cantor, and I represent the appellee father. If I can begin by following up on a couple of exchanges between the court and my sister counsels. First, Justice Desmond asked both attorneys whether this is a case of removal. And my sister counsel for the appellant today responded, yes, it is. And I found that response interesting because in her brief, she takes a slightly different tact, where she says, I believe on page 27, that this is not a petition for removal per se. And coming in, I had prepared to respond to that by saying, well, that per se is doing quite a bit of heavy lifting, because of course I agree with the position in the brief and disagree with her position here today. It is not a petition for removal. It is not removal. And the reason for that is a matter of statutory interpretation. Removal is effectively a term of art. It's within the section of the statute that refers to resignation, removal, and other post-appointment proceedings. And that's key. You could read that title as giving context as to what the statute is about. And it's about removal of someone who's a permanent guardian. And of course, this guardian is not a permanent guardian. She is a temporary guardian. And another exchange that the court had, I believe, between Justice Hand and Attorney Spanos was regard to the difference between the two. Counsel for the appellant referenced that she didn't see any legislative difference between permanent and temporary guardianship, which prompted a question from Justice Hand. And of course, there is a very, very, very significant difference between the two. My sister or the judge indicated the time period that the guardianship, the temporary guardianship lasts, that it lasts for 90 days. And that is true, but of even greater significance is what must be shown to get a permanent guardianship. And that is that you must prove that the parents are unfit and incapable of caring for the child. And of course, that has not happened here. The Massachusetts court has never found, that either of the parents, my client or the mother, are unfit, or that the child is in need of permanent guardianship. All the court did was say, because there are exigent circumstances, we will appoint a temporary guardianship. Now, that was in 2022, and that temporary guardianship has been extended on a rolling basis. But that does not change the fact that she has not been found a permanent guardian or that the parents are unfit. And so just as a matter of statutory interpretation, I think it bears noting that what appellant is asking for today really is unprecedented. She does not cite any statute, any rule, any case law that specifically says that you can do this, that you could award counsel to someone who has not been appointed a permanent guardian. Justice Desmond asked Attorney Barrow, well, what's this all about? Why would you object? And she answered that question, I thought, very appropriately. I have, let me just echo that and respond by saying that I, on behalf of father, object, and he's objected, because of paramount importance in a guardianship proceeding is not the interests of the guardian. Of paramount concern is the interest of the child. And to award a guardian, a court-appointed attorney, paid for by the Commonwealth, does not necessarily advance the interest of the child. All right, that counsel would, by professional obligations and others, would be advancing the interest of the guardian. And that may not be in square or in alignment with what the child wishes. The child is ably protected by counsel and by the GAL who's appointed and could be reappointed. And so it's just very important that to know that that may not help the child's case, which is, of course, what the probate court was appropriately concerned about. My time is up, but if your honors have any questions, I'd be happy to answer. Otherwise, I could rest on the briefs.
I just have one quick question. I was curious, my understanding is the single justice initially denied relief. The guardian came back essentially asking for reconsideration, and the single justice then considered referring the question to a panel, but invited the parties to respond, and the parties didn't respond. Is there a reason for that?
Judge, you know, I'm appellate counsel, and so all of that predates me, so I don't have an answer to that. But I would note that this was all in the context of whether the New Hampshire order controls in Massachusetts. And the reason that the court was so concerned about that is because mother or the guardian could have just filed that New Hampshire order in Massachusetts and enforced it in Massachusetts, and it didn't do so. And so that's why the court was interested in engaging that in that question.
Thank you.
Thank you.
Thank you, Attorney Cantor. Attorney Hopper.
Good morning, Your Honors. Natalie Hopple on behalf of the appellee child for purposes of the appointment of counsel, but I would suggest that my client's an appellant for purposes of jurisdiction. Just to clarify that. Justice Hand inquired as to home state jurisdiction. When I read my sister's reply brief, took a trip through 3 cases in Massachusetts. Anisha, Daphne, and then there's a very old, but I think illustrative opinion from 1974, the opinion of the justices. My reading of those 3 cases, Daphne, Anisha, and the opinion of the justices, is that because this is an out-of-wedlock child, mother's residence and intent, right, is New Hampshire, and that is where my client was domiciled from the commencement of the Massachusetts action. So when I read the PKPA and the Massachusetts CCJA cases, I have trouble understanding how the Massachusetts court established jurisdiction over my client. The initial order from New Hampshire was 4/19/22, and that was the permanent guardianship, and that's at RA 49. 6/9/22, Massachusetts enters a temporary guardianship and has not taken any steps to confer with the New Hampshire court to reconcile the federal statute, the PKPA statute, and the Massachusetts jurisdictional statute. So I have trouble understanding how our state came to assert jurisdiction in the first instance, especially in light of those 3 cases. Just because I'm limited on time. One other, I think, clarification that in terms of the temporary status of the guardianship, we have a temporary code section, it's 5-204. We have the right to seek to vacate temporary guardianships. So to argue, as my sister has, that a motion to vacate is the equivalent of a petition to remove, I think conflates 2 separate sections of the guardianship statute. You have 5-2012, which deals with post-appointment, as my brother indicated, but 5-204 is temporary. This is a temporary guardianship. It does not transmute into some type of permanent guardianship without any type of evidentiary hearing. Even at the temporary level, as you would see in a care and protection with a 72-hour hearing, the only evidentiary hearing that I'm aware of occurred in New Hampshire. So there's no basis in Massachusetts by which this temporary guardian has somehow morphed into a permanent guardianship.
At the hearing in New Hampshire, did the judge in New Hampshire question whether or not Massachusetts had authority or jurisdiction?
My understanding is at the time of the New Hampshire evidentiary hearing is that the New Hampshire court, the Massachusetts case had not been initiated. So the New Hampshire judge was holding an evidentiary hearing based on witnesses and documentary evidence in New Hampshire, issues the permanent guardianship, and then the now temporary guardian then goes to Massachusetts, files a competing petition, which I'm a little bit perplexed how it even made it through the clerk's office. My understanding, much like domestic relations cases, is that you have to affirmatively state if there is a contemporaneous within Massachusetts or another state has an active case open, and that usually would trigger a clerk's office to say, hold up, you cannot file this, or it has to be a permission to file in the probate and family court to even get in before a judge. But then we have the Massachusetts judge, which issues a temporary, despite there being a permanent still in existence in New Hampshire. So you've got 2 competing orders, which the federal PKPA statute is intended to prevent from happening, because Massachusetts is supposed to be giving full faith and credit to the New Hampshire order or permanent guardianship that's already in effect. So a lot of this could have been solved, with a telephone call between two judges, or perhaps even convening an evidentiary hearing between two states. Anecdotally, I've seen probate court judges do this via Zoom now, because we have that. So this is one of those scenarios where, going back to the beginning, I struggle to find how Massachusetts asserted jurisdiction. I would offer to the court that I believe it's Section 7 of 209B gives the court some remedial relief here, and where a temporary guardian has unclean hands, as they say, to kind of rewind all of this, to go back to the beginning and set things right in terms of jurisdiction, which I don't think existed at the outset of the Massachusetts case being filed, the petition being filed. And I think I'm over. If there are questions, I'm happy to answer.
Hearing none, Attorney Hopple, thank you kindly.
Thank you, Your
The matter
Honors.
stands submitted.
Thank you.
The next matter on our docket is 25P0737, the Commonwealth versus Christopher K. Maderos.
May it please the court. Good day to the panel. I'm attorney Ian Kahanowitz. I am the attorney for the appellant, Christopher Maderos. I'd like to begin my argument with one of the issues I brought to the panel today, which was the closing arguments of the prosecution in this case. During the prosecution's closing statements, he mentioned that the complainant was the trial counsel indicated that the complainant was coached on video. The trial counsel, of course, said he didn't do anything improper. He's not implying that. However, the prosecution took note, and he basically speculated that the trial counsel said these comments, that he was coached. However, a prosecutor has to limit comment in closing. The evidence has to be a fair inference can be drawn.
When you say coached, was there a distinction between leading and coaching?
There is a distinction.
Okay.
The distinction is this. What trial counsel was trying to do was, when they watched the video, and the video is not in evidence, it was not put into evidence.
But was it shown as a exhibit?
It was shown.
Shown for ID, I mean?
Yes.
But never offered?
Right. It was never offered. And so what the distinction was there, Justice Desmond, was that trial counsel was looking at the state of the mind of the complainant. He was making inferences that he did not remember regarding that the interviewer had to prompt him. Instead of just the complainant coming out with the answer, the interviewer had to say, did this happen? Did this happen? Where the complainant would say, yes, the complainant didn't do that on his own. The prosecution took it upon themselves and said, well, he was, my brother over here, he infers that he was coached. There is no, by what I read, what the transcript shows.
So that was in direct response to what the government perceived as the closing, as the point that was trying to be made in the defense's closing argument.
Correct, Your Honor. That is exactly right. And I think that prejudiced, because he did object to it. I think that prejudiced my client because, number one, you cannot say things that are speculative here. Like I mentioned to the panel before, there is a fine line between speculation and drawing an inference. I think that's an outright, speculation. And considering the evidence that was presented in this case, that was left out, when you look at the total case, we have my two other issues I will put in what I'm saying now. One, we have evidence that was never disclosed, And two, we have a juror who I believe, from what was shown in the transcript, that had bias. And
Well, just to go back to the coaching for 1 second and see if I understand what you're saying. A prosecutor was not referring to evidence at that point.
No.
That was a characterization of defense counsel's argument, right?
absolutely.
But doesn't that happen all the time?
It might happen all the time, but it doesn't make it does not take away the fact that it would be prejudicial.
I mean, there was no misstatement of the evidence. He's just saying, well, the defense is saying this. That's not correct.
Even if, and I understand your question, even if we were to assume that, the prosecutor has to limit his comment to not only the evidence, but also the fair inference, because a closing statement is also considered an argument.
Prosecutor is allowed to respond directly to the defense closing argument. So, within the limitations of the trial.
Correct, Your Honor.
And so, in the closing argument of the defendant, he said, does it help to prove his credibility that there's long pauses, that there's details, or that there's lack of a detail, that the interviewer has to suggest certain things? I'm not saying he did anything improper, but he certainly suggested things, right?
Right, he was drawing an inference, but he did not say. And
He didn't use the word coached.
That's right, that's what the trial counsel said. He said, look, and then you just quoted verbatim, which is in my notes here. But coaching is a negative. He never inferred that. He might have made inference that, again, the complainant needed help remembering, but under no circumstances did he say coached. If that answers
I think
your-
we understand the argument.
Okay.
What would you like to turn to?
All right. My next argument, pretty much, again, there is prejudicial error here with the evidence that was missing. As you've read the transcript, there was a motion for discovery by the trial counsel. There was evidence missing in this case. And that evidence came from a Facebook messenger from the complainant to the appellant. And what he said was, I want to come live with you. If you looked at the second video, that was in 2017, the police took my client's phone. It is documented in the police report that they had screenshots.
Undisputed, right? Undisputed that
It's
he showed them the phone
undisputed.
and they took a picture of it.
Right, it's undisputed, it's in there. And so what this does is this is heavily prejudicial, that it was not put into evidence. Again, if the evidence was cumulative and there was other factors here, one might be able to find, well, okay, it would be a harmless error. This is not the case.
Isn't the prejudice blunted by the fact that the defendant was permitted to testify to the existence of the messages and what they said?
Yes, even with the defendant, well, the complaint, the appellant, excuse me, the appellant testifying, that would be pretty much the smoking gun as proof, because it's testimony versus testimony. I believe, again, the Commonwealth has to prove guilt. And with that, by not...
But that wasn't part of the Commonwealth's case, correct? At least to your point about proving guilt, the statement from the victim over Facebook was helpful to your client. It wasn't a component of the Commonwealth's case.
In my recollection, the complainant did not testify regarding those...
Right, but your client did.
My client did.
Right.
Is that going to take the place for the Commonwealth producing that evidence? Absolutely not.
Wasn't he allowed to argue that they provided the screenshots to the Commonwealth, that if the Commonwealth had anything contrary to that, you would have seen it? I mean, wasn't he allowed to argue that?
He was
Did the
allowed
judge
to-
permit him to argue that?
He was allowed to argue it.
So what's the prejudice?
So here, what I'm bringing to this court is to prevail on these claims, my client had to show that the undisclosed evidence here, even though he argued it, was exculpatory, made a specific request for it, which he did.
But what was undisclosed?
The screenshot of the complainant's Facebook messages to the appellant said, we are talking about allegations of rape, which happened years before. Years later, we have evidence which the police took pictures. They have it. Their whole logic of taking those pictures was to preserve
Okay, so
evidence.
it was disclosed, it was just not preserved in a form that would have been
Correct.
helpful to the defendant.
Correct.
Okay.
So,
Nevertheless, that information that the alleged victim had reached out to the alleged perpetrator after the fact and said, hey, can I come live with you? That all was before the trier of fact, right?
correct. It was. And the thing is that, look, the standard is clear. My client can demonstrate prejudice from that nondisclosure. It is clear. The trial counsel even indicated early on, even the prosecutor said, well, look, my brother said here, you know, the Commonwealth doesn't have it. It's up to the Commonwealth to produce all the evidence that would make this trial a fair trial. Leaving that out leaves a huge hole because, again, the Commonwealth's case is not strong. There is no other evidence that was presented here.
Let me ask you about your citation in your case, because you rest your argument on Commonwealth versus Bowden. In my read, B-O-W-D-E-N, Bowden. So,
Oh, Bowden,
yeah.
yes.
So as I read that case, that stands for the proposition that a judge cannot take a certain issue away from a jury. A judge can't instruct a jury that you're not to consider inadequacies in the Commonwealth's case and so forth. But you cite that for the proposition that it's an error for the judge to conduct a trial without the exculpatory screenshots. Can you
Right.
point out to me in the case where it says that?
What I can say is that the SJC has said, when you use the Bowden defense, okay, first of all, its probative value has to outweigh any prejudice to the Commonwealth here. And when he used the Bowden defense here, that probative value, the evidence against a risk of unfair prejudice oversteps anything else when it comes to the Commonwealth. It's not prejudicing the Commonwealth. That evidence is needed. That is a smoking gun here. That is clearly what Bowden means is the police did not fully, the Commonwealth has not fully disclosed. The police botched up. They already had it. It says it right there. We have the evidence. It was never produced.
This is a piece of circumstantial evidence that occurred after the fact, right? And the material in it still came before the jury. The government would say, it was his Facebook page. Why didn't he go back and retrieve it from his Facebook page?
And I will answer that. I don't know if the justices here have a Facebook page. I have a Facebook page. Sometimes it's hacked. Sometimes you change a different account. And sometimes it goes away. But it's not up to the defendant to produce that. It's up to the Commonwealth to produce that evidence.
And so your position is because they didn't have the screenshots, they should have been barred from moving forward at trial.
I do. I think it's extremely prejudicial, especially with the lack of evidence of the Commonwealth.
Where did counsel ask for that as a sanction for spoliation or loss of the evidence?
So I don't believe that he asked for it as a sanction, but what he did do is he produced, the day before, he issued a motion for discovery. This was the fourth attempt, I think, because there was other counsel before trial counsel here.
Okay, but understanding, I'm sorry to interrupt you, but understanding that there were requests made, the documents were not produced, there was no specific request for dismissal based on the failure to produce that. There's no, I take it the answer is there's no other request for any other sanction, exclusion of evidence, limitation in some way of the testimony, nothing like that. Is that correct?
That's correct.
Then is
However,
there anything other than Bowden or Bowden that says that the judge was obligated sua sponte to dismiss the case based on the failure of the Commonwealth to preserve that particular evidence?
there is a case, and I think I cited it, but I'm not quite sure. I understand your question. Let's see if I have it here. Let's see, I'm going to move it back.
That's fine, your time is limited if it doesn't
That's all right.
come immediately to hand.
I would argue again, yes, I would argue prejudiced. And again, I did put in Commonwealth versus Lager, 448 Mass 585, 2007. I would argue, yes. I understand your question, Justice.
Is that a case that got dismissed because the government failed to produce this evidence?
I don't know the outcome of that.
Okay, well, do you have a case where the case got dismissed?
I don't. Maybe Commonwealth versus Bateman. I believe that is a recent case in 2023.
When you say maybe, what does that mean?
Maybe, I'm not quite positive on that, Justice Desmond, okay? I am not positive on that. The last issue I'm going to address rather quickly was we had a juror here. Once again, the trial counsel, he did not object. There was no for cause. There was no preemptory challenge. However, there was two issues that came out of this. Number one, he didn't know English very well. Number two, he had an autistic child with special needs. And again, the complainant here had a variety of special needs. He was on IEP. He was diagnosed with oppositional defiant disorder by the doctor, as it indicates in the record. And what I'm going to argue is the hardest standard. It is a substantial risk of miscarriage of justice here, because again, trial counsel did not object to this juror. Now, what
if anything, can we glean from that?
Excuse me again?
What, if anything, can we glean from the fact that trial counsel did not move for cause or exercise a preemptory challenge as to this juror?
I don't know. Looking at the transcript, both the judge, trial counsel, and the prosecutor were going round and round trying to see what was the understanding that this juror would have. But I will tell you, when the juror, and I quote, said, "I guess if I more understand the case and I know what autism is, or kids with disability, their vulnerabilities against this type of predator." He is saying predator. That, it's in itself, should have prompted the judge to excuse the potential juror because of just that. He is mentioning, he's a predator. He has a preconceived notion. And there's two things. Number one, is there bias? And number two, is there a preconceived notion? I think with his response to that, absolutely.
The conversation didn't end there, though, right?
No, it continued on.
It didn't end there.
It continued on. The judge was looking more at his understanding of English, to my understanding. Oh, it's excellent, you know, he understands English, but he does say, besides what I've just read you on the first point, was that if you speak too fast, if the terminology is a little more difficult, he's not going to understand.
This was a high-ranking person who worked for the Attorney General's office.
Certainly it was. Certainly was, Your Honor. But again, I think that what I presented to this court is enough to at least show the court that there might be a reasonable possibility, is all I'm looking for here, that the trial itself might have been tainted.
I think we'll leave it there, counsel. Thank you. That's your time.
All righty.
Good morning. May it please the court. Stacey Gothier for the Commonwealth. It is the Commonwealth's position that the defendant's convictions here should be affirmed, starting with the first issue about the exculpatory evidence. The defendant would not be entitled to a new trial based on the non-disclosure of exculpatory evidence unless three prongs are met. The first is that it was in the possession, custody, or control of the Commonwealth. The second,
was it in the possession, custody, and control of the Commonwealth?
well, it does appear that they took his phone, Your Honor. Also, that it was exculpatory, which we're also not disputing that. And then the third is that he must show prejudice. And I would suggest that here, in this case, he cannot show prejudice. First, the judge let defense counsel have the defendant testify uncontradicted that the victim sent these messages and the substance of the messages. That was uncontradicted. No one asked the victim. The victim didn't weigh in on that at all. So first, that was uncontradicted. She then allowed the defense attorney to argue in his closing that essentially if the Commonwealth had any evidence to contradict what the defendant said the victim sent him in the messages, that we would have produced it. So I would suggest there was no prejudice shown in this case for that reason. Also, this isn't really like a police case. This isn't like a third-party culprit or a whodunit, or a drug case that requires a lot of police investigation. This is a sex case that essentially comes down to the credibility of the victim versus the defendant. And in this case, the victim, he was, at the time of trial, he was 29 years old, although he was, he had some developmental disabilities, but he was 29 years old. He certainly was aware that the defendant was his stepfather and was able to identify him. He disclosed the abuse prior to the police even getting involved in the case. So I would suggest there was no prejudice. Certainly, the police should not have misplaced his phone. They took his phone, apparently on the video. That certainly shouldn't happen, and we don't condone that. However, I don't think that he was able to show any prejudice by those messages or by the phone not being produced at trial. In addition, the defendant testified that these messages were via Facebook Messenger, and although the police had his phone, there was no evidence that they took his Facebook account or they closed his Facebook account.
Did they actually take his phone, or did they take screenshots from his phone?
So it's hard to tell, Your Honor. There was talk about how the detective had taken screenshots of his phone. However, if you watch the recorded interview, which I sent up, it appears at one point at the end, towards the end of the interview, his phone is on the table in front of him, and then the recording kind of stops, and then it starts again about 10 minutes later, and his phone is gone. And a detective is in there going over a consent form and asking him for his password. So it appeared that she was going to take his phone, and the phone disappeared. So again, I guess it's kind of unclear. In any event, I know prior to trial, both parties were asking for it, both the Commonwealth and the defendant. So we don't know what happened to it.
Should it give us particular pause on our prejudice analysis that this is, as you pointed out, a credibility contest between the victim and the defendant?
Again, Your Honor, I think if you do find that there is some prejudice, I don't think it's any prejudice that the defendant, that would require reversal. The defendant could have cured the prejudice on his own by getting his own Facebook messages. He hasn't shown that he wasn't able to do that. And if there's no further questions on that issue, I'll just move on to the closing argument quickly. I would suggest that the prosecutor's closing argument that when he used the word coached, I would suggest that there was no error in that. It was a fair response to the defendant's argument. The defendant had argued in his closing that the sane interviewer had, quote, suggested certain things to the victim when he was, answering their questions. I guess you could say coached is a little bit stronger than suggested, but I mean, they're very similar. We're certainly allowed to respond to the defendant's, closing, and I'd say also that, at least initially, in the first time he said coached, he then said, the prosecutor says it was suggested that the victim was coached, that he was led along. So I kind of think that, like the led along part, I think that neutralizes coached a little bit, that, he was led along. I think that's a little neutralizing. However, certainly enthusiastic rhetoric, strong advocacy, and excusable hyperbole are not reasons to certainly reverse a case. The judge instructed the jurors that closing arguments are not evidence, and it's presumed that the jury followed the judge's instructions.
Does it matter that, as I had asked your brother, the prosecutor wasn't referring to evidence. The prosecutor was referring to defense counsel's argument. Isn't
Yes,
that a
yes,
very
it was
different thing?
I would suggest it was a fair response to the defendant's argument that the interviewer was, quote, suggesting certain things to the victim before he made his, his disclosures. And if there's no further questions on that issue, I'll go quickly to the juror issue. The defendant claims that, juror 34 was biased because English wasn't his first language, and he had an autistic son, and the victim in this case was developmentally or cognitively delayed. Again, there was no error in seating the juror. The defense counsel indicated that he was content. He did not ask for a challenge for cause. He did not remove the juror with a peremptory. I'd also note that, the judge extensively voir dired the juror. It covered approximately 15 pages of transcript. She talked to him about his English language abilities. She found that his English speaking abilities were excellent. He hadn't missed any of the concepts that she had talked about prior to him being called up to the sidebar. Also, he worked in IT at the Attorney General's office. And then as far as his son, he indicated that there might possibly be a bias, and the judge continued to, she continued to voir dire him on whether he would actually be biased. I believe at the end he said he thought he could be unbiased. I think that certainly the judge who's, seeing the juror, and she's certainly able to make credibility determinations, and she has broad discretion to find that a juror is competent to be seated. I would suggest she did that here. 15 pages of transcript. The trial counsel had no objections. It was actually the Commonwealth. I think the Commonwealth wanted him removed for cause because he worked at the Attorney General's office. So I would suggest there was no error here either. And if there's no further questions, I'll rest on my brief for anything not addressed.
Thank you, Attorney.
Thank you, Your Honors.
The matter stands submitted. The next matter on our docket is 25P0596, the Commonwealth versus James Benjamin Carver. Remind the parties that this case is partially impounded. Attorney Samel? I hope I pronounced your name properly.
Sorry,
I pronounced your name properly. Is it Samel?
Semmel.
Semmel, sorry.
It's 50-50. Good morning. I'm Catherine Semmel, appearing for the Commonwealth. This case involves the 1984 fire at the Elliott Chamber Rooming House in Beverly, which claimed the lives of 15 people. The motion judge allowed the defendant's fifth new trial motion on the basis that new fire science and new eyewitness ID science each independently warranted a new trial. The crux of our claim on appeal is that the judge both overstated what was new science and undervalued the other evidence in the case.
So the new science is really the fire science, as well as the advancements and evolution in eyewitness identification, correct?
Yes.
Those are the two areas that the judge primarily pointed to.
Correct.
And with respect to the fire science, the government's theory in 1989 was that the fires, just from 10,000 feet, fires don't burn down, right? That fires burn up, and that we can discern the point of origin of a fire based on the lowest point of, my words, the lowest point of the burning, essentially. Is that the crux of that?
That's one. There were really three principles, yes.
So that was one. The other one was that his words are that they debunked the theory of negative corpus, where you determine that we can't find what any accidental cause of the fire, and because we can't discern what an accidental cause of the fire was, then we conclude that it was an intentional fire.
Well, the three principles that I would identify that we agreed were new fire science are the fires don't burn down, that alligatoring, shiny, blistering is...
Which is suggestive of an accelerant.
Yes, and the same for the Formica swirls. Those are clearly new science. Our expert agreed, everybody agreed. Those are based on new science. The negative corpus is a little bit different in that it's not a science. It's a procedure. But our argument below was primarily that even though fire investigator RAHN said you can determine the point of origin from the lowest point of burn, that is not all he did in this case. He didn't just say that and then go home. He looked for drop-down fire. He looked for electrical causes of the fire, which were not at floor level, but were wires that were up higher in the doorway. He did consider accidental things like cigarettes and spontaneous combustion and lightning storms. And Trooper Bradbury, who did not testify but did his own investigation in the case, called in an electrical inspector to check more broadly the building to look for electrical causes of fire. So to say that they didn't follow this process, that they just eliminated accidental causes and then said it must have been set, I think ignores their evidence in the case, which was the newspapers which had been moved, which were some physical evidence in support of an arson. The movement of foreign materials into an area is a proper consideration, as Dr. Byler testified at the motion hearing. And while they were wrong, they also relied on things that they thought were affirmative evidence that an accelerant had been used.
Was one of the primary theories that the government rested on was that fires don't burn down?
I think that it was testified to. I mean, but I don't...
Was it argued in the closing argument?
I don't recall if he said it. It might have been. But I think the focus of the argument was, it was always on the newspapers, the coincidence of the newspapers being moved into the alcove in a 15-minute period during which the fire, started. They were dropped up at 4 o'clock. At 4:18 a.m., there was a fire that was called in. And so yes, I'm sure, I mean, he testified to it. It was part of our case. But it wasn't the only evidence in this case of an arson.
Wasn't it undisputed that it was arson? I mean, wasn't the defense, part of the defense, that the fire was set by somebody else, that there was like a satanic cult or something, and someone else set the fire? So why would even the cause of the fire be an issue now if it wasn't at trial?
I think the theory is that had the defendant known all of this, perhaps he would have made a different choice about whether or not to contest the arson science. If he knew that some of these principles that Fire Marshal Duran relied upon were wrong.
But as I read it, these principles came out in 1992, the change in fire science. And this is the defendant's fifth motion for a new trial. His second motion for a new trial was filed in 1994. Shouldn't it have been raised in one of the prior new trial motions? Isn't it waived if it's not raised?
Yes, I think it could be considered waived because of the intervening motions, and I'm sorry, I did not argue that. Yes.
Do you argue it's waived in your brief?
I'm sorry?
You argue it's waived in your brief.
I do not argue that it's waived because he didn't raise it in prior motions for new trial. I argue that other things are waived. That things that their expert relied upon that are not based on new science, like general criticisms about how things were done, that those were waived. And I'm sorry, I did not argue that, that it was waived by failure to raise it in the prior motions for new trial, although that is a reasonable view.
So what about the alligatoring?
The same. I mean, that was that they relied on that as some evidence that a flammable liquid was used, as affirmative evidence that a flammable liquid was used. And is
that newly discovered, that alligatoring does not necessarily suggest that a accelerant was used?
Yes. Yes, I agree that it is. And your phrasing is exactly correct. There is no evidence, there is no reason based on the new science to say, well, an accelerant just definitely wasn't used. It's just that you can't affirmatively say it was. And I think that nuance and the way you phrased it, which I agree with, is really important in this case because, for instance, when the argument is made that this impacted Christine Coletti's confession because she specifically said that the defendant confessed to using gasoline to set the fire. I mean, the impact is minimal. Yes, we did use that. The coincidence, the inspector says that a flammable liquid was used, and she testified that the defendant said that that's how he committed the fire. But it doesn't negate the confession in any of the same ways as, for instance, in Rosario.
Well, the confession's being attacked for a separate reason, not really on the science, right? The confession's being attacked on. There's some argument that maybe Coletti didn't believe it when I think it was Coletti, didn't believe it when he made that claim to her, right?
I think that the part of the defense argument is that correcting this science would also affect the impact of Coletti's testimony about the confession.
Since when does a witness's personal opinion as to whether or not someone really believed what he said, why would that be relevant? I mean, if someone says, I did it, is it proper for a witness to say, well, I really didn't believe he meant it? Since when is that proper?
I don't know. I know that the judge foreclosed some of the testimony, but they did permit her to testify to some extent that she had questions about the validity of his statement based on his neediness. So it did come in. It did come in at trial. I think that if you take the new fire science and you take it at its greatest strength, which is that there could be an alternative theory of how this fire started. I think that the judge just erred in the way he considered the other evidence in the case and how an alternative theory would have impacted that evidence in the case. I mean, first of all, as Justice Hodgens pointed out, who knows if the defendant would have challenged the arson with this new information. I mean, the problem, the common sense problem, is always the newspapers. I mean, the convincing a jury that a fire accidentally started in the ceiling, and there's no heat source in the ceiling that has ever been identified, that it accidentally started in the ceiling when newspapers were moved for no discernible reason, and people saw a person buy the newspapers at the time the fire started. It was going to be an uphill climb, even with the corrections in this case, and it is unclear whether the defense ever would have gone down this path of doing that.
There was some mention that the fires, the newspapers, which were bundled, correct? They were bundled by some twine or something of the sort. Is that right?
Originally, they were.
Okay, and that they were partially still intact after the fire.
Yes,
That
some of them
one
were.
of the officers or the fire instructor came over and kicked them kind of out of the way.
Correct.
And that the twines that were wrapping the fires were still in somewhat in place, right? And that there was some theory that, well, it couldn't have been that because they didn't even get completely engulfed in the fire, which was supposed to have had accelerant on it. About the newspapers.
In the motion for new trial.
Right.
Yes. And that is based on the fact that a firefighter who kicked the newspapers away said he believed they were tied. That is the extent of the information as to the fact that they were still tied.
So our review is for abuse of discretion for the judge, correct?
Correct. Or clear error.
Clear error. So are you arguing clear error?
In some of his findings, yes. The judge, I think, found principles were based on new science that were not, or umbrellaed the entire testimony of Dr. Byler as based on new science. For instance, the drop-down science, the electrical investigation, his theory that the newspapers were not a competent source to start this fire, which was, of course, disputed by our expert at the motion for new trial. Those are some clear errors by the judge. The judge also just, on the eyewitness ID evidence, I was greatly troubled when the judge repeatedly referred to Dr. Franklin's conclusions regarding Stanley Clark's unreliability. That's just not proper, and there's a SJC case directly on point with this same witness, that is not proper testimony. Certainly, she could testify to all the factors and that might have impacted Stanley Clark's reliability, but she could not opine as to whether or not his IDs were actually reliable, and that would have been improper. And I think when you look at Rosario, where an alternative theory of the fire was presented, the judge in that case did not find that that was an independent grounds for the new trial motion, but the court relied on the confluence of circumstances between that and a devastating undermining of the confession, which was the only real evidence in that case, in addition to the fire science. In this case, there was so much other evidence. There were confessions, there were threats, there was motive, there was consciousness of guilt, and all of this other evidence, which I don't feel like the motion judge properly weighed in this case, and that was error. And yes, I agree that the review is for an abuse of discretion, but when this court is reviewing the other evidence in this case, which is based on the trial record, it is in as good a position as the motion judge to assess and weigh that evidence.
Tragic case all the way around. So as I read the record, the defendant was angry because one of the people who lived in the rooming house was now dating his old girlfriend or ex-girlfriend or recently ex-girlfriend. And he had told him, this was on July 4th of 1984, is that correct?
Correct.
And he had told him that if I see you with her again, I'll kill you, or you should burn in hell, something like that. Is that right?
There were different versions of exactly what he said.
And then the rooming house went up in flames that night.
Yes.
Got it. Anything additionally you'd like to add?
I'm sorry?
Anything additionally you'd like to add?
Not unless you have questions. I will rest on my brief.
Just one question. Who has the burden on a fifth motion for new trial?
The defendant has a burden.
Burden to show what?
I'm sorry?
Burden to show what?
To show that substantial justice wasn't done in the case. Or in this case, to show that newly discovered evidence casts a real doubt on the justice of his convictions. Thank you.
Thank you, Attorney Semmel. Attorney Whitmore?
Thank you, Your Honors. Good morning. May it please the court. My name is Charlotte Whitmore, and I'm here with my co-counsel, Lisa Kavanaugh, on behalf of James Carver, who's here in the courtroom today. Mr. Carver served 35 years of wrongful incarceration before being released in February of 2025.
Well, we're not sure, right? That's why we're here.
Correct, Your Honor.
Okay.
The only issue before this court today is whether the motion judge abused his discretion in finding that the newly discovered scientific evidence bearing on the fire investigation and the eyewitness identification would probably have been a real factor in the jury's deliberations at Mr. Carver's trial.
In the case that lays out what the standard is what? Are you relying on Moore or Gaines? Which one of those cases that says that you get a new trial if what? If justice hasn't been done, if we're concerned whether or not justice has been done, what's the standard?
So whether or not justice has been done is the overarching standard, and the motion judge has the discretion to consider any factors in determining whether or not justice was done. The more specific standard for newly discovered evidence, as explained by the Gaines court, is a two-part standard. So first, is there newly discovered evidence? That's evidence that could not have been discovered at the time of trial with the exercise of due diligence. And second, would that newly discovered evidence have been a real factor in the jury's deliberations, or would probably have been a real factor in the jury's deliberations? And the Gaines court also explains that this court's review on the judge's weighing of those factors is an abuse of discretion review.
So how would fire science have played any factor back in 1989 if the cause and origin of the fire was really not an issue at all? And in fact, part of the defense was that the fire was set.
Yes.
So why now is it an issue if it wasn't an issue then?
It wasn't an issue then at all. Your Honor makes a very good point. It wasn't an issue then at all because of the state of fire science in 1989. And so the science that was believed by everybody at that time.
It was more than that, though, because the part of the defense was that someone else set the fire, that it was part of a satanic, whatever, a ritual or something. That was the defense.
Right, that was
relying on the fact that the fire had been set.
correct. The only defense available at that time based on the state of the science was mistaken identity or that somebody else set the fire. There was not an available defense that this was an accidental fire because of the fire science and because of what we now know indisputably is incorrect.
Yeah, but that's, all right, but see, this is inconsistent with, as I read Commonwealth versus Amaro, the SJC said the mere fact that if the process were redone, there might be a different outcome. That's not enough for a new trial.
The mere fact that if the process was redone,
And, oh, now I'm going to rely on new science, the mere fact that it's redone and I'm going to change my theory of defense, that's not enough for a new trial. At least the SJC tells us that.
well, the SJC in Ellis and Gaines and Rosario tells us differently. So in Ellis, the SJC specifically looks at how the defense strategy would have been different and how the defendant's closing argument would have been different. That's what the Ellis court said. The Gaines court says we look at how the newly discovered eyewitness identification would have changed the trial. How would that have been a real factor? And so when science changes, right, I mean, you can look at DNA cases for this. Perhaps the only defense available to a defendant at the time of a rape case is consent because DNA isn't available. So he argues consent even though that's not true. And then DNA, I'm sorry, Your Honor, and then DNA comes back indicating he's not the rapist. Of course that's relevant even though his defense at the time was consent. So the defense at the time, and the motion judge explains this, the defendant had to rely on a mistaken identity defense because everyone believed, the Commonwealth's experts, and the Commonwealth does not dispute this, everyone believed, the Commonwealth's experts and the defense did consult with a chemist at the time of trial, but that alligatoring meant accelerant. If you have accelerant, it's an incendiary fire. You don't have an accident defense. So we've got alligatoring, smoke squirrels, and the depth of char. Everyone agrees, well, that means that there was accelerant. If you're faced with that science, you can't mount an accidental fire defense, even if it truly was an accidental fire, which is what Dr. Byler opines it could have been. You also have the fact that back then, they believed that the lowest point of burn was absolutely the point of origin. No debate. The lowest point of burn here is the floor of the alcove where these newspapers were. And so the defense was not able to mount an accident defense. It wasn't available to the defense because of the indisputed science at that time. When NFPA 921 was first published, and then there have been many iterations of 921 since 1992, in which the science has continued to change. Negative corpus wasn't rejected by the NFPA 921 until 2011. And so this science is evolving like all the other science that this court grapples with: shaken baby syndrome, DNA, fire science, eyewitness ID science. These are changing the way we look at cases. And of course, we have to look back and look at how this case could have been tried if we know what's the accurate science. We can't rely on inaccurate science to hamper a defendant into a defense that was the only option he had in 1989. And so this court is looking at whether the motion judge, who held a 4-day evidentiary hearing, heard from 3 different experts, considered hundreds of pages of trial transcripts and police reports, and published a carefully reasoned 68-page decision, whether that falls outside the range of reasonable alternatives. And we know that it doesn't fall outside the range of reasonable alternatives because we have cases like Gaines and Rosario, in which the Commonwealth's evidence at trial was that those defendants made inculpatory statements. And in Gaines and Rosario, the Commonwealth presented evidence that those defendants made inculpatory statements to police officers. In Rosario, it was a contemporaneously documented confession to police. In Gaines, it was a confession to police that was overheard by another police officer. And yet, the judges and the SJC affirmed in those cases that despite those inculpatory statements that were alleged at trial, the new fire science in Rosario and the new ID science in Gaines entitled those defendants to a new trial. So inculpatory statements alone, we know per se, don't indicate that the judge abused his discretion. This judge meticulously went through all of the alleged inculpatory statements in this case and explained why not only did the fire science affect the Commonwealth's sole theory on the cause and the origin of this fire, but they affected the way in which the Commonwealth corroborated the key witness, Coletti, as Justice Desmond pointed out earlier.
It seemed to me, as I read the judge's decision, it seemed to me that he did not give any weight to the defendant's statements. I mean, these are extraordinary statements. I'll burn your place just like I did in Beverly. He said to another witness, he didn't mean to hurt anyone. And she said, well, what do you mean? He said, in the fire. And then to yet another witness, he brought up the subject, a coworker. He said, well, I'm sure you've heard rumors about me. And the coworker says, yes. And then the defendant says, yeah, shit, yeah, I lit the fire, but they have no proof, so I'll get off because they have no proof. And the motion judge just kind of glossed over all this and said, well, you know, he was emotional. He just didn't give it any weight. Is that fair?
The motion judge went through each of those inculpatory statements and explained how the fire science affects those statements, and also explained how those statements were attacked at trial. So, for instance, the threats that Your Honor referred to, there were contradictory witnesses about whether those threats were made and what was said the night before the fire started. In terms of the statement to the coworker, that coworker didn't come forward for many years, and he didn't even believe the statements, which is why he didn't come forward.
And but why would that be? Why would that be relevant? What a witness thinks of a statement? I mean, the witness is there to tell the jury what was said, not to give an opinion on how much weight to give the statement. That just struck me as very odd.
Well, the witness is the only person who knows how the defendant, if the defendant said this statement, was behaving, the demeanor of the defendant, factors that would weigh into whether or not this was a believable statement. And the judge found that the delay in all of these witnesses coming forward and the fact that they didn't believe it was part of his analysis. He doesn't rest his whole analysis on those things, but he certainly goes through, he doesn't ignore the inculpatory statement. The standard for the motion judge is not whether there's sufficient evidence on which they could still convict Mr. Carver. The standard for the motion judge is not whether another jury, given the Commonwealth's new theory of how this fire started, could potentially convict Mr. Carver. That's not the motion judge's standard. His standard is whether the new fire science and the new ID science would have factored in to the jury's deliberations. Would they have considered this? And where the Commonwealth relied on accelerant to prove arson, that is how the Commonwealth proved that a crime occurred. The motion judge spends over 3 pages of his opinion going through how important accelerant was to the Commonwealth's case, how they emphasized Doran's now discredited conclusions about the fire science to prove that this was an intentionally set fire, and how they used that fire science to corroborate Christine Coletti, who said that allegedly Mr. Carver told her that he poured gasoline onto newspapers to light this fire. Now we know from Dr. Byler's testimony, which the motion judge credited, that the newspapers were not a competent ignition source, and they did not start this fire. So a jury now presented with the Commonwealth's new theory, which the jury never heard, which is that the newspapers without accelerant are a competent ignition source. At trial, the Commonwealth emphasized that accelerant had to be used. This jury would now also hear Dr. Byler's testimony that it's simply not the case that the newspapers started this fire. They do not matter. They're not relevant to this case now because we know they didn't start the fire. That impacts the credibility of Ms. Coletti's testimony. And we know furthermore that even given all of these alleged inculpatory statements and the alleged threats, that this decision does not fall outside the range of alternatives, of reasonable alternatives. And we know that both from the Gaines and Rosario cases that I cited, but also the Cascone case, which is a Superior Court opinion that's in the record appendix. In that case, it's nearly identical facts. It's a 1984 fire. The new fire science shows that the Commonwealth's point of origin and cause were incorrect. In that case, the defendant allegedly threatened a resident of that apartment building the night before. He got in a fight with her, and he allegedly threatened her that he was going to get her back. The fire starts a few hours later. He's indisputably at the scene, which we don't have here. That defendant is indisputably at the scene. And he gives an inculpatory statement to an acquaintance a few days later, which is overheard by that person's father. And the motion judge found in that case that it was not, that the fire science would have been a real factor to that jury. And the Commonwealth agreed. They agreed in that case that the fire science would have been a real factor, and of course did not appeal. And so we have all of that to base that this is not outside the range of reasonable alternatives.
So that was Judge Callan's decision. Does it matter that the defense may have tried the case differently if they had the benefit of the new science? Not what necessarily what would have gone before the jury, but some of the decisions that the defendants made in figuring out what the course of the defense was going to be may have been different decisions if they had the benefit of the new science.
Absolutely, Your Honor. That's a key part of the real factor analysis. And the Ellis court, the SJC in the Ellis case makes this extremely clear because they look at the closing argument. They look at how the defense's closing argument would have been different piece by piece and how the
in that case, a bunch of corrupt police officers, that was Judge Carol Ball's case in the Superior Court. A bunch of corrupt police officers had pointed to Sean Ellis as the murderer of police officer Joe Mulligan.
Yes, Your Honor. Oh, sorry.
So I guess at bottom, the question is not whether or not, I mean, with a new trial, the defendant may still be found guilty. It's not whether or not he's going to be found guilty or not, right?
Absolutely. That's the standard. And Your Honor brings up the Ellis case, which goes directly to the Commonwealth's point about whether some of this evidence was newly discovered or not in terms of the fire science. The judge found that it was all newly discovered because the fire investigators at the time were fixated on the lowest point of burn, and they didn't follow the scientific method. So all of their conclusions following that and potentially eliminating accidental causes were misplaced because of where their focus was. But in the Ellis case, as Your Honor points out, there was new evidence of police misconduct, but there was also evidence of police misconduct that the defendant had raised in a prior new trial motion. And that court held that because it's all related, you have to consider it all. You have to consider the new evidence of police misconduct and the evidence of police misconduct that had been previously raised in order to accurately assess whether it would be a real factor in the jury's deliberations.
Did the motion judge consider the prejudice to the Commonwealth
In what sense?
in allowing the motion? Where 40 years has gone by, a lot of witnesses are dead, you're not going to have live testimony in a retrial? Did the judge give that any consideration at all?
The judge did give that.
I didn't see it.
I'm not sure if he specifically words it that way in his motion. I mean, that's not part of the standard for a new trial that he's faced with. He certainly did give a lot of credence to the evidence that the Commonwealth put forward and their arguments, and he heard from their expert as well, who had a different theory of how the fire started. You know, in this case, not only do we have a battle of experts between the defense post-conviction expert and the Commonwealth's post-conviction expert, but the Commonwealth's own post-conviction expert disagrees with their trial expert. So it goes even further than that, and he gave weight to all of that.
In a motion for new trial, is it proper for the court to consider whether or not the government's case may have deteriorated over time?
That's not part of the standard for a motion for new trial. No, Your Honor.
Anything additionally?
I'm sorry?
Anything additionally?
I didn't get to the eyewitness ID science, but I see my time is up, so unless Your Honors have any questions, I'll rest on the brief.
We've read the briefs. We're familiar with the arguments.
Thank you, Your Honors.
It's your time. Matter stands submitted. Tragic case all the way around.
Thank you.
Court will take a short recess.
All rise, please. Court is now in recess.
RAHN. We will now resume our session. And the next matter on our docket is 25P 1019, the Commonwealth versus MATEUS Andrade, or Andrade.
Thank you. Good morning. Michelle Dame for Mr. Andrade. May it please the court. I want to first briefly address issue 2, which is for Mr. Andrade's conviction for assault and battery with a dangerous weapon resulting in serious bodily injury. The Commonwealth did concede that that conviction should be vacated because the charge is a lesser included offense of mayhem and was not distinguished at trial, which act constituted each crime. So if there are no questions on that, I will move on to the next issue. Mr. Andrade's conviction for assault and battery on a family or household member should be vacated, as the evidence was insufficient that Mr. Andrade and Ms. Sequeira were family or household members. There was a written motion for required finding, which was filed, and that was included in my record appendix. That was filed at the times of the motions in limine, but the judge took no action on the motion.
So with respect to that, was that kind of an omnibus motion when it was filed?
That one was for all charges.
And so then at the conclusion of once the trial was underway, was there some discussion with the court about specifically which charges they were moving on the required finding? Was there a discussion with the court about that?
The way it played out is it was at the end of the Commonwealth's case, and it was at the end of the day. The judge had kind of hinted at which charges he did not think that the Commonwealth had.
Was there a discussion with the court specifically about which charges you're moving for required finding on?
The defense attorney made argument on specific charges.
Which ones were those?
Those were, I believe, the two that were actually required out. And they were the ones that the judge had indicated the day before that he felt that some of the evidence was lacking. And I believe even at that time, earlier on, defense counsel was making some arguments towards some of the other charges. But I would suggest that the written motion does preserve the issue and that the court should only consider the evidence as it came in during the Commonwealth's case.
Is the defendant required to move, if by filing an omnibus motion, does that obligate the defense counsel to seek dismissal or required finding of not guilty, rather, on all of the charges?
I don't think there needs to be argument made on all of the charges. I think once that...
Not my question, though. The question is, does it require that the defense counsel move for required finding on all counts, or is there discretion to defense counsel to limit the portions of the motion that defense counsel presses?
What didn't find a case either way. My argument and my position would be that the written motion, once it was filed, preserved the issue for all of the counts and was not limited to just what was argued orally at the close of the Commonwealth's case.
How then would the judge have notice, or let me ask this, given the transcript here that says, so you're not, and I'm looking at transcript 3, page 15, so you're making a motion for required finding of not guilty as to all the counts. Defense counsel said, just based on our discussions and my research overnight, I would move on the restraining order and on the witness intimidation charge. Assuming that I've read that correctly, how does that put the judge on notice of the defendant's intention to seek a required finding of not guilty on anything other than those two charges?
Based on the written motion. And I think that based on the conversations and the statements that the judge had made to the defense attorney the night before, the judge had even indicated, hey, these are the charges that I am thinking that there is not sufficient evidence on. So the judge was aware that all of the charges there were on the table and was sort of highlighting to the attorneys, these are the ones that I am seeing they're having some issues with. And I know that normally it doesn't really matter if there is that motion made, because regardless, the court reviews the issue. But here there is some concern there because the state of the evidence changed once Mr. Andrade testified, and he himself concededly would have established enough for there being that substantive dating relationship. It really was Ms. Sequeira's testimony that we would suggest did not provide that evidence. Her testimony was just that she had known him for 2 years, described their relationship as being friends, and that he supported her without really going into detail of how that happened, that they eventually had a relationship and became closer to each other with time, but didn't really describe what that specific relationship was or how long it had lasted. And she never called him her boyfriend during her testimony. She testified that they had never lived together, they never married, they never had any children. And in fact, she testified that she was married to somebody else during the time that she had known him. So it really does matter if that written motion is what the court is bound by, or if it's only based on the specific arguments that the defense attorney made. I was not able to find a case that specifically highlighted that. And I mean, I know normally this written motion is filed at the close of the evidence. In this case, it was filed prematurely at the motions in limine, and the judge didn't deny it at that time. He just took no action and said that it would be considered at the close of the Commonwealth.
Is it fair to say that the judge couldn't take any action at that time because the case hadn't been tried?
It's true. It's true.
Okay, so
But he did say that
I can't allow it before we begin.
he couldn't allow it, but he could have denied it at that time or denied without prejudice until the time of the trial. If there are no further questions on that, I would move to the judge's instruction on what a family or household member is. During the instructions, the judge added in that a family or household member could be found if there was evidence or if the jury found that the parties resided together or were related by blood. And that is an incorrect definition of what a family or household member is. Under the statute, it is only those who are married or have been married, have a child in common, or are in a substantive dating relationship. And here, even though there was no objection, there was a substantial risk of a miscarriage of justice because Mr. Andrade testified that the two of them did actually live together.
But was there a live issue about whether, or how live, I guess, was the issue about whether there was a family or household member relationship between the two as defined not by 209A, but by the criminal charge?
It wasn't something that seemed to be strongly argued, as it was one of the less serious charges that Mr. Andrade faced. But still, given Mr. Andrade's testimony, if the jury credited that testimony, that alone would have been enough for them to find that a family or household membership, that a family or household member relationship existed based on the judge's instructions.
But if it wasn't if it were the case, if we were to conclude that it was not a contested issue, in fact, because, for example, in opening and closing, defense counsel made reference to the relationship between the two in a way that the jury could have found compatible with the statutory definition. How do we then say it created a risk of a miscarriage of justice, that a substantial risk of a miscarriage of justice, based on the fact that there was another way in which the jury could have mistakenly
They could have found a substantive dating relationship, but I would suggest that the evidence of a substantive dating relationship was not so strong and so overwhelming that it would have prevented the jury from not finding that relationship. And where we had specific testimony from a witness saying that the two parties lived together, that based on the judge's instructions, again, that one sentence alone would have been enough for them to find that relationship under the judge's erroneous jury instructions, that there still was the likelihood, the possibility that the jury would have found differently had they been instructed just on the three correct definitions, and really only one that even would have been possible in this case, because there was no testimony that they were married and there was no testimony that they had any children together. If there are no further questions on that, I will move to my last issue, that Mr. Andrade's conviction for home invasion should be vacated, as there was insufficient evidence that he was armed with a knife at the time of entry. In order to sustain a conviction for home invasion, the defendant must have been armed with the dangerous weapon at the time that he enters the home. And there was no evidence that he was in possession of the knife at the time that he entered Mr. Cuerra's home, as opposed to gaining possession of that knife once he was inside.
Was it reasonable for the jurors to infer that he was armed when he entered the home. I believe the testimony was that the victim saw him come up, pull up in the driveway, that he came into the home and immediately the door enters from the outside to her bedroom, I think, and that he immediately forced his way into the bedroom and began to attack her. And she testified that she didn't have any pocket knives in her house.
So he does not go directly from the outside of her apartment to inside the bedroom. There is sort of that common area that he goes into first before he then breaks the door down somehow to get into the bedroom where she was. So she testified that she did not know that he had a knife until he started stabbing her, and that she first noticed the knife actually in his hand when she started bleeding. Now, she did say that she saw him arrive at the house in the car, but she did not say that while he was outside or when he got out of the car that she saw anything in his hand. And she actually testified that she did not actually see him come in through the front door. So really, she does not actually see him in the house until he comes into the bedroom. And yes, she did testify that there were no knives in the house, but she did also live with a roommate. So
I'm sorry, she did what?
she lived with a roommate. So this isn't a situation where she lived alone in that apartment and would be able to account for every item that is in that house. This is a situation where
Well, she said a little more than that. On cross-examination, she was asked, and when the defendant came into the room, isn't it true that you swung your knife at him? No, never. I don't have knives at my house. He came with his knife in his hand. And that seems like pretty powerful evidence that he came in with the knife.
said that, and my take of that is just her assuming that based on her saying that this was not a knife that she had seen in the house. Because she said she did not actually see him enter the front door. She did not see anything in his hand when he was outside of the house, getting out of the car and then going into her house. And again, I do think the situation would be different about her saying that there are no knives in the house. If she lived alone, she would be able to say that. But when there is a roommate that she lives with, who knows what that roommate is weaving around the house.
Was that argued before the jury?
That specific argument, no, was not argued before the jury. And again, the roommate did testify, and she did not say that was not my knife as well. And the Commonwealth does cite to Commonwealth versus Lewis for the proposition that it would be reasonable to infer that he had a motive to hurt the victim and likely would have come to the house armed to accomplish this. But in that case, the victim said that it looked like the defendant had something in his hand when she observed him outside of the home. So it was reasonable to infer that the knife that he then used to attack her was the same object that he had seen, that she had seen in his hand. And again, here we had no testimony that she saw anything in his hand when he was outside of the home. And if evidence tends to equally sustain either of two inconsistent propositions, here that would be that he entered the home with the knife or that he gained possession of it once he was inside. Neither of them can said to have been established by legitimate proof. If there are no further questions, I would rest on my brief. Thank you.
None? Madam, thank you. Attorney Palumbo.
Good morning, Your Honors. Karen Palumbo for the Commonwealth. May it please the court. I would disagree with counsel in that the defendant did not file a motion for required finding of not guilty on the assault and battery on a family or household member. As the court already pointed out, the defendant specifically said that he was just moving on the restraining order charge and the intimidation of witness charge. There are cases that say a generalized motion may preserve the issue, but it's in cases where the issue is contested or is obvious, a specific issue. And I would suggest there were many issues in this case, and that issue, or whether or not they were a family or household member, was not put before the judge in order to determine a motion for required finding of guilty on that particular charge. The defendant has already pointed out, or counsel has already pointed out, that the defendant and the victim were in a relationship. There are factors to that. The length of time, it was approximately 2 years. The type of relationship, they started as friends, then it grew into a dating relationship. The bouncer at George's the night earlier in the evening before the attack overheard the defendant say to Tony that the victim was his or belonged to him. The defendant also, when he entered the victim's house on the night of the attack, he entered through the doorway, which led directly to the victim's bedroom. There were two entrances. He knew where to go and where to enter the premises. In addition to that, and had the relationship been terminated, it was only terminated 2 months prior to this attack. In addition to that, the victim in November, when trying to end the relationship with the defendant, had sought out and obtained a 2-week restraining order against the defendant. That can be considered by this court because the criteria for a 209A is also whether the two parties are family or household members. So I would suggest the evidence in this case is overwhelming that they were, in fact, family or household members. With respect to the instructions, the 5 years could not have an effect on the jury's verdict because it was only 2 months prior. It was incorrect. It was from an old instruction, I think from a 2009 instruction. The fact that they're related by blood, there was no evidence at trial that...
Fact that what?
Whether they were related by blood. There was no evidence at trial that the victim and the defendant who were dating were related by blood, so that couldn't have caused any problem for the jury. With respect to that they resided together, yes, there was conflicting testimony, as the defendant said they lived together and the victim adamantly denied living with the defendant, although he would come to her house. But I would suggest that the uncontested testimony, absent the testimony of the defendant that they resided together, which I just highlighted, the type of relationship, the length of relationship, the familiarity with the victim's apartment, the testimony that the victim belonged to the defendant, and that the court granted a protective order was enough to negate any risk that living together instruction influenced the jury's verdict in that regard.
What's the best legal authority for that particular point? I have seen more cases in my own research that deal with the absence of an instruction on a required element than I have when the jury is incorrectly provided with additional bases.
Yeah, there's not many on that. But in any event, in Commonwealth v. Robinson, 444 Mass at 106, 107, the erroneous instruction did not equal a substantial risk of a miscarriage of justice where the error did not go to a contested issue, another important point in this case, or otherwise compromise the theory of defense. And I would suggest that, as the court already pointed out, that was not the theory of defense in this case. With respect to the armed home invasion, circumstantial evidence is sufficient to sustain a conviction. And the evidence here that the defendant twice earlier in the evening threatened to kill the victim, then showed up at her house, forced his way into her bedroom, chased her out of her bedroom. It was not as if he hung around in the bedroom and grabbed things, chased her out of the bedroom into the living room. She didn't realize he had a knife until she was bleeding and being stabbed. Similarly, the roommate who saw the defendant assaulting her didn't realize the defendant had a knife in his hand until she saw the blood. And I would suggest that the jury was well within reason to infer that the defendant, who intended to kill the victim, came to the house armed with a knife.
And his testimony was that he entered the home at her invitation, and upon entering the home, she attacked him with the knife and somehow stabbed herself in the back twice in the course of attacking him.
Yes, that was his testimony. So he doesn't deny being there, but he says it was the victim who did that, and that's a matter of credibility, which is the exclusive province of the jury. And clearly the jury here believed the victim. Does the court have any questions?
Hearing none.
I would ask the court to affirm the defendant's convictions except for these assault and battery, serious bodily injury, and would ask that the court vacate that conviction.
What you concede is a
in the circumstances,
lesser offense of mayhem.
In the circumstances of this case.
On these facts.
Yes. All right. No further questions.
No further
I'll
questions.
rest on my brief.
Matter
Thank
stands
you.
submitted. Thank you. Our next matter is 24P 1371, Thomas v. Thomas. This matter is partially impounded.
I may?
You may.
It's afternoon, so, afternoon. We're here asking that the judgment dismissing the complaint be overturned, be reversed. This is a simple case where there was a contract entered into under the Kavanaugh case, the court, where there's a separation agreement incorporated into a judgment. The court looks to contract law and contract terms and provision, contract rules to determine the interpretation of what became the judgment. Here, the issue revolved around, and it's on page 281 of the appendix, the first appendix, provides that the I'm sorry, not page 231. The husband was to pay 30%. Husband shall also pay 30% of any self-employment income to the wife as alimony.
So is the question at bottom whether or not, and I know that the husband, I believe from the record, was a part-time tax assistant or tax accountant that he did on his own, but is the question whether or not he was self-employed by, was it Northland?
Northland, yeah, he was.
Yeah, right. Or not? Is that really the issue?
No, I don't think that was the issue. His it doesn't say employment in the agreement. It says that that he's to pay 30% of any self-employment income.
So was he self-employed when he was working for Northland?
Correct. That's his source of income on his K-1s, on his tax returns. Everything that he had was self-employment income from Northland for several years before the divorce and for all of the years following the divorce.
But isn't the question for this, because it's a contempt, isn't the question whether the provision requiring payment of any self-employment income, whether that was ambiguous, whether that was a clear and unequivocal order?
Yes and no.
Okay.
Because,
go ahead.
Go ahead.
No, go ahead.
Because under Wooters, Skolnick, and the other cases, a judge can order, without finding contempt, order the payment where it appears from the terms of the document or the terms of the agreement that the back alimony is owed. That is one of the principles, and that you do not have to show clear, unambiguous. There's clear, unambiguous language with a clear and unquestioned disobedience. I followed that up. That's not the exact standard.
Under the Burchell standard, right? More or less.
So, but even if so on that level, no, we didn't have to. And in fact, in the request for findings, we pointed out Wooters and Skolnick and asked for an alternative finding that he be ordered to pay what the contract called for, which is the back alimony at that point in time.
Apart from the contempt?
Apart from the contempt.
But was the appeal only from the order of contempt? I'm not trying to nitpick, but that's my...
The appeals from the judgment and all the I believe, if it's my usual language, it was the judgment and any subsidiary findings and anything else that made up the judgment. So, but there were no findings. The judgment did not talk about the separate concept and the separate rule regarding the interpretation of the separation agreement under contract law, under contract terms.
But looking at the contempt part of it first, just to keep that separate, why was the judge wrong to say that there was no clear and unequivocal order in the requirement that there be any and all, that payments be made from any self-employment income, where self-employment was not further defined, and under cases like Kobayashi, the breadth of that term might be subject to disagreement?
But this term, it can't be subject to disagreement.
Why not?
Because under the facts, and there was pages after pages of Richard's testimony that this was his only source of income was self-employment income. There was the testimony of the CPA for the partnership that it was self-employment income and had been for a number of years. As far as any other source, in his argument later, in his testimony later, that it was applied to his tax preparation sideline business, just when they obtained the divorce, number one, it's not on the financial statement. Number two, it's not mentioned in the separation agreement. And number three, it was represented to the probate judge that that business, that whatever it was defunct, and there was no income from it. In fact, there'd been no income from it. It had been showing a loss for the 2 or 3 years prior that he had operated it. So that, he wrote this, and he clearly understood what self-employment income was, and it says any. It doesn't say, it doesn't limit it. It says any. And under the Clausen case, if he wanted to limit it to a certain type of income, he could have done so by drafting it into the agreement, which he wrote, and he didn't do that.
But the parties didn't make that agreement, I guess is what maybe I'm missing the boat, but it seems to me like that's conflating two things that you're describing here. One is the term, generally speaking, in an objective way, ambiguous, and two, is it ambiguous as to what their particular understanding was? And maybe that goes to your earlier point about the two different approaches that were being taken, one a contempt, one there should be reformation. Or
no, I have to disagree with you because he wrote the agreement, and it says 30% of any self-employment income. And he understood what that meant, because if you read the testimony, he said, I went over this with my lawyer line by line. She had my K-1s, and this is what I wanted. This is what I wanted for the separation agreement. He brought it to the courthouse. Anna and her lawyer looked at it, and they accepted it.
How do we know that he knew that that's what it meant? How do we know that in his mind's eye, he's not thinking self-employment is my tax business or not?
Then Clausen obliterates that position, because if he had intended that it apply only to that sideline business, it should have been in the agreement. And that's what happened in Clausen. They said it has to be in there, and there are other cases strictly on contract law that says it has to be in there to show the intent of the parties. The problem here is that you have an integrated document. And the integration clause in this document is probably one of the most comprehensive I've ever seen as to what it covers. And it specifically, and he wrote it, it specifically says he's not relying on any prior writings, any prior negotiations, or any other comments made prior to the execution.
We're talking about the term self-employment. How do we know that in his mind's eye, he was not thinking of self-employment as what people may commonly understand as self-employment, something that you do on your own and not working for a company of sorts?
Well, he wasn't working for the company. He was a partner. So it's a partnership. So he's not working. He's not an employee. So there's a difference there. And number two, he was a CPA. He had a master's in tax. He was the designated contact with the IRS for the partnership for tax issues. And he was the one that partially, at least, determined what his type of income was, what it was characterized as self-employment income. He could have chosen, by the way, in that agreement to have, instead of saying any self-employment, he could have said distributions, interest income, dividend income, or there were 3 or 4 other types of income that he were on his K-1s that he could have limited the 30% to, but he didn't. And that, in the case, the name escapes me, but the cases talk about a contract. What is written is the apogee of the intent and purpose of the agreement by the parties, not to be changed or amended by extrinsic evidence or testimony somewhere down the road that, well, maybe, maybe I didn't think this was today I don't think this is such a good idea, it's such a good deal, and now I want to change it, so I get up there and I say, that's not what I intended, okay? I mean, the problem is, and you go back to the rules regarding an integrated document and the ambiguity issue, and it says, the case says that you have to look at the terms of the document without any extrinsic testimony or evidence of what the parties intended. And that's under, I think that's even under
Well,
Kavanaugh.
that's fine, and, you know, and I tried to approach it that way myself, and so I read it without thought of testimony and so forth. And self-employment seems to be an ambiguous phrase, because on the one hand, I think self-employment, I think of sole proprietorship. But on the other, self-employment, oh, it means you're paying self-employment taxes, so that can take a variety of forms.
He had no other source of income other than self-employment income. That's
But
all.
isn't it, would you agree that there is some ambiguity just in the phrase? You think that that's
Well,
self-employment?
Not in this set of circumstances. I would absolutely disagree with you, because we're not out in the world somewhere just having a conversation between a couple of laymen or lawyers or whatever about what the concept of self-employment is. This contract was done within a specific confines of what the parties' situation were at the time. And that situation was he had self-employment income and had had it for many, many years prior to the divorce and following the divorce. So that when he chose that term, this guy's not stupid, he's not unsophisticated. He knew self-employment was what he was receiving from Northland, and he knew that his tax preparation business, whatever it was defunct. It was gone.
So why do you think he's taking a different position now?
Because he doesn't want to pay the money.
Why would he agree to it?
He
agreed to it in the beginning.
He thought it was a good deal for him.
Why would he think it's a good deal for him?
Well,
explain that to me. He's not dumb. He's a sophisticated business person. He's got all these degrees. Tell me why he would think that that's a good deal.
Because he came up, he and his lawyer determined that should be the basis of the compensation.
Why, I'm asking you? How does that deal
Because
benefit
maybe
him?
he thought that was going to limit his exposure somehow to what he was going to have to pay. That's something that I really have to take exception to, because I don't know what was going through his mind at the time. Because
isn't that what the judge was trying to figure out?
Well, but
isn't one of the inquiries, what did the parties intend?
Not in this circumstance, not with this integrated document, and not with the terms of the terms of the agreement. Before you get to what the parties thought or whatever else is out there, there has to be a determination looking at the four corners of the document without any extrinsic consideration of what that means. That analysis was never done in this case. That's one of the issues. It was never done. There was never a consideration done of the integration clause and whether or not, under the terms of the integration clause, any extrinsic evidence should have been allowed in. And the other issues that were not addressed was the word any. There's nowhere in this decision where it's discussed about the effects of the word any on the 30% of any self-employment income. And under the Metropolitan case, the Metropolitan Insurance case, every word in a document, every word in a contract has to be considered. So let's go back for a second. Let's assume that tax thing was not defunct at the time he got his divorce.
What? Excuse me?
That tax preparation business he had wasn't defunct at the time he got the divorce. So if you even take that, it says any, which would include his Northland self-employment income from his partnership and the income from the tax preparation business.
Sometimes we see language that says any and all. Is there a distinction between any and all?
No, I looked in the dictionary. Any can mean all, can mean everything. I mean, it just runs down the gamut. And I think if you put on your word processor and go over to review and you put the word any in, it comes out with a list that includes that term.
Let me ask you this, because your brother, I thought, made a very compelling argument where he said, all right, well, let's just for a moment accept what you're saying is true and then kind of march through the numbers. If the husband's making $166,000 back in 2006, about $45,000 is going to alimony, under your theory, an additional 30% of that income, or $50,000, has to also be taken out, which would mean about $95,000 is taken out, which is about 57% of his gross income. Is that what you're saying? That's what he agreed to?
I'm saying that's what he wrote. And his issue of the double dip,
There's a distinction between whether that's what he wrote. I don't know that anybody's contesting that that's what he wrote. But what did he intend to agree to? That's the question that we're trying to get to the bottom
well,
of,
but
right?
you can't get to that point unless you make a determination that the agreement was ambiguous on any 30% of any self-employment. And that was never done in this case. Not only that, the concept of contra pro forentum was never considered in this case either because he wrote it. And if there's an ambiguity, it's got to be construed most strenuously against him under Bowser versus Chalifour. And that element was never considered in the decision as well. And, you know, and that issue about the double dip, in the brief, we said, we're going to give him credit for the $1,750 he paid every 2 weeks against whatever the 30% was. And don't forget, if you look at his financial statements, he absolutely lied on every one of them. I mean, one year he said on his financial statement $150,000 in income, and his gross income on his tax returns was $1,200,000. And, you know, that was never disclosed at any time to the court. So, you know, when you look at what he was doing, he didn't want the information to come out, and he was not, let me put it this way, I don't think he was acting in good faith because he did not define, he did not provide open and clear disclosures, and under the terms of the agreement.
I think we're going to have to interrupt you. I see that's your time.
I got a minute left.
No, you're
Thank you.
a minute over.
Good afternoon, Your Honors.
Good afternoon.
Nice on behalf of Mr. Thomas. I think what you just heard is trying to have it both ways. The defense that they've raised consistently is you have to just look at the agreement itself, the four corners, nothing further. And that runs square into the problem that Justice Hodgens raised is what is self-employment income? And it's not defined. And it can mean many different things. So, and to be fair, sorry, I forgot my glasses. Judge Allen did address that because she specifically wrote, reading the exhibit and agreement in its entirety does not resolve the question of how self-employment income is to be defined. So she found that it wasn't clear on its face what that meant. In order to make his argument, my brother also started talking about Mr. Thomas's background, education, a whole host of factors outside the four corners of the document. So even he quickly jumped outside the pages of the agreement to bring in other extrinsic evidence to try to make his argument. So, but once you do that, that house of cards in his argument completely falls apart because he's ignoring all the other extrinsic evidence that runs counter to it. Critically, this agreement was a result of people represented by counsel. Each party had counsel. It was negotiated through counsel. We know what the positions of the parties were pre-trial because they had to submit pre-trial memorandum where they outlined it. When you look at those pre-trial memorandum, what's in the agreement isn't what was in their pre-trial memorandum, which means there was some settlement. It's an agreement. They came to a compromise different than the positions they'd advanced at the outset. Now, I think it's a very reasonable inference that even though it was drafted by one counsel may take the lead in the actual typing and writing, but it's not a contract of adhesion, and there's never been any indication that it was a take it or leave it. Here's what I wrote, you have to sign it. No, there was a back and forth. Because in Ms. Thomas's pretrial memorandum, she specifically talked about taking the certain percentage of income, applying it to a child support calculation, and then reference what are we going to do as a percentage of his tax business income. And that's where it becomes in, because my client was clear on his first financial statement. He broke down his income into wages and self-employment income on page 1 of his financial statement. And there was testimony at trial that my brother didn't acknowledge or touch on. Mr. Dolly, the president of the company, came and testified. And what he described is something that's unusual, but he was credited by the judge, and we have to give deference to the judge as the trier of fact. And she found him credible when he said, we call everyone employees. So it becomes a misleading term when you're called an employee, and they ran their regular pay through a payroll company, ADP. So Mr. Thomas was getting regular paychecks, which is different than I can attest as a partner in a law firm. I don't get regular paychecks. I get a monthly draw and quarterly distributions, and there's a true-up at the end. So the regular paychecks go to our W-2 employees. And Mr. Thomas specifically broke out, and it was noted in Ms. Thomas's pretrial memorandum, they had tax returns that had been made available to them. They were going to call an expert to go through everything. So they had a Schedule C on that tax return, as Judge Allen noted, but he broke it down and put wages as one thing, because I think to that family, they lived off his paychecks, and maybe some extra money would come in, but it was his self-employment income. He meant the tax business. That's what he testified to, and he was credited for that. And Ms. Thomas testified she didn't know how this sentence would work anyway. So I think Judge Allen was correct when she said, on the face of the document, there wasn't this meeting of the minds, and as you noted, Your Honor, the Kobayashi case makes clear that was what's a deli. It sounds easy and obvious, but it's not. Self-employment's not easy and obvious. And when you look at it, as I broke out in my brief, if this gentleman is as sophisticated as being pointed out, no one's going to agree to 57% of their gross income. He couldn't have lived off of that. It makes no sense. And the fact that their own expert had to credit him for it at trial, not just in the brief, at trial on his charts, there's no direction in the four corners of the document to do that. There's nothing that's, in fact, it specifically says you can only credit certain things, FICA, health insurance. It doesn't say credit the payments made. That inherent contradiction Judge Allen seized upon and noted all the things that weren't in this agreement that one would expect. And I thought she made a very sophisticated catch. I frankly admit I didn't catch it myself and should have. When she compared the complaint for modification, the last one in 2018, and saw the counterclaim that Ms. Thomas wrote. And she noted in her footnote, that counterclaim, same counsel, by the way, represented her in that action and the contempt, and they wrote at that point in time, self-modifying piece was illegal and unenforceable. Now they want to enforce it. Which is it? That's an ambiguity, right in its face. And so Judge Allen was forced to get into the minds of the parties, and she found that there wasn't a meeting of the minds rightfully because Mr. Thomas thought that he was paying on his taxes, and it wasn't defunct at the time of divorce. It wasn't making money, but it wasn't defunct. He testified clearly that he ended that business 2 years later after the divorce. So at the time of the divorce, and in particular, his first financial, he was actually making a small amount of money. But he testified and was credited with his testimony. It just wasn't, it was too time-consuming for what it was yielding to justify its continued existence. A significant amount, if you read the trial testimony, and it wasn't raised, and I didn't want to bog the court down in my brief, but I think it's important to note, the bulk of the trial was spent on trying to attribute as much income as humanly possible to Mr. Thomas through these K-1 statements, where Mr. Dolly testified clearly and unequivocally that they operated as a real estate development company. And in order to succeed to do another deal, they had to keep funds on hand. And those funds came from the sale of other developments. And that income, though, that profit realized on that one deal, if he didn't distribute out to the partners but kept it for another deal, it was still going to be taxable to them because it was a flow-through entity. So that's not fair. It would make it tough to retain your workers if they would get taxed for monies they never physically received, because that can get pretty onerous pretty fast. So he testified clearly that he would make payments for the taxes. They would gross up payments so that there would be no net detrimental effect to the person by not having received the money but being taxed on it. That's the number they seek to attribute income to my client to base an astronomical support order that went far beyond the lifestyle of the parties. That hasn't even been touched on. The charts that were submitted at trial show Mr. Thomas has had a slow and steady increase in income. He started out as a W-2 employee, became a member of the LLC, but it was incremental over the years, and at the time they divorced, the chart's pretty clear. They never lived beyond that payment. That was the highest watermark at the time of divorce of the income they'd received during their marriage. They did not live a marriage based on hundreds of thousands of dollars in income. And a sophisticated analysis, and if I had been representing Mr. Thomas currently, I would have made that argument to the court saying, you can't have support. Alimony can't exceed the lifestyle of the marriage. So if a marriage is based on 160 as a high watermark, if someone earns $500,000, the extra income, that doesn't go to support.
To follow up on the question that Justice Hand asked at the beginning, can we decide this case, because the case seems to have evolved into, from a contempt case into like a kind of a tax case of some sort, but if we see an ambiguity in that language, isn't that the end of it? Like,
It
we
is-
don't have to
it is the end of it.
unpack the other 99% of the case, right?
Correct.
I mean-
That's what I argued at trial. In Ray Burchill makes crystal clear the burden is on the plaintiff to provide clear and convincing evidence of disobedience of a clear, unequivocal command. That's contempt. And I pointed out in my brief, you can't have a contempt of contract claim. It's a breach of contract claim. Evidentiary standards difference, preponderance of the evidence. There's a 6-year statute of limitations on that. There's not a statute of limitations on contempt of a court order or judgment. So you're exactly right, Your Honor. Once the ambiguity was there, and it was on, my client never missed a single payment. And I think it wasn't commented on, and it's crucial. This wasn't Ms. Thomas's first bite at the apple. It wasn't even her second. It was her third. And the contempt was filed literally days after settling a complaint for modification, which all of this information, everything was available to her, never raised to Judge Donnelly, who handled that complaint for modification. So I completely concur that the answer is the ambiguity means my client can't have been contemptuous. Judge Allen couldn't have been any clearer in her decision that there was no clear and unequivocal order. He thought one thing, lived by it, abided by it. Ms. Thomas abided by it for years, filed modification and another modification, never raising the issue. Only at the very end, over 13 years later, suddenly this novel argument comes up, fraught with the peril that the math provides, fraught with the peril of the party's intent, fraught with how do you analyze it in light of all of those intervening years of behavior. Because you are entitled to look at the behavior of the parties in assessing a contract if there's any ambiguity. And the parties' behavior shows that they lived by the terms as understood by my client.
Did I read that she believes she's entitled to $780,000?
Correct. If there's no further questions, I think my brief was clear. I think I've made my points. I'm happy to give the time to the next case.
Hearing none, you're a gentleman. Hearing none, the matter stands submitted.
Thank you so much.
The final matter on our docket today is 25P1508, Patricia RAHN versus Deborah Hay.
May it please the court, Bill Sheehan for Deborah Hay. At issue, a single one-page document. At issue is one single question, albeit a question with two parts. Can the instrument reasonably be found or arguably be based on the concept that this is a deed as opposed to a contract or as opposed to an agreement? The answer to that question is this instrument cannot be found to be or concluded to be a deed.
How was it that Ms. RAHN, why and how is it that Ms. RAHN was initially contacted?
I'm sorry, Judge.
Why and how is it that Ms. RAHN, I'm going to call her Ms. RAHN, is that how you pronounce her name?
Patricia RAHN, the plaintiff,
Patricia
yes.
RAHN. How is it that she was initially contacted, or why is it that she was initially contacted from your side of the V?
So in 1995, this instrument was recorded, and then 30 years later, Patricia RAHN, realizing that she was in the way of this transaction.
How did she realize that?
She learned that from counsel named Ray Perkins, who had heard from a title insurance company that this instrument constituted a potential blemish on the title, and it had to be taken care of.
And do sometimes, and I don't know, I'm asking, do sometimes contracts cloud titles?
Contracts can cloud title, but what's important here is that the plaintiff has expressly eschewed any reliance on a contract theory. Her sole theory in this case is that by virtue of this instrument, she became an owner then and there in 1995 by way of what she now calls a deed. And I'd like to have the court look at first the language, the key language that is in that instrument. I also want the court to consider how Patricia RAHN conducted herself for 30 years from 1995 to 2025.
Which is she took no action to suggest or to show that she somehow was the owner of this property.
Took no action whatsoever. Didn't do it within the first 2 years while she was still living with Mr. Allen, then for 23 years while Mr. Allen was alive, and while they were separated, never made any kind of a claim that she was an owner, even 5 years after Mr. Allen's death, from 2020 to 2025. Never says anything about being an owner.
Doesn't Judge Lang say that he's not putting his thumb on the scale with respect to whether or not Ms. RAHN will be successful at a trial in any way? He's saying, considering the low bar on motions to dismiss, there's enough in this document for a reasonable mind to conclude that she believed that she was a 50% interest holder in the home.
That is certainly what Judge Lang said. With all due respect to Judge Lang, I think of all the judges I've appeared before in the Superior Court, he's one of the top judges I've ever appeared before in the Superior Court. But this is one he got wrong. And I'm going to ask the court to take a look, although I get a little bit ahead of myself in saying this, but when you get a chance, take a look at the bottom of page 5 and top of page 6 of Judge Lang's decision. That is found at the record appendix, pages 65 and 66, because there he was dealing with what I would suggest to this court is the key language. The key language is that both Mr. Allen and Ms. RAHN agreed that Ms. RAHN was unable at the present time to hold joint ownership of the property.
That may be true. And it strikes me, and I don't know, that they were trying to effectuate some type of a workaround. They wanted her to be able to continue to receive payments for disability for her child, at the same time recognizing that they were equals in this relationship, and though he purchased the home, she moved into it at the same time that he purchased it, it sounds like to me, and he wanted her to feel that she was a part owner of the home. I just can't put your name on the title, otherwise we're going to miss out on the disability payments for your son.
If you don't want to put your name on the title, it can't be a deed, Judge. You can't acquire an ownership interest in real estate except by a deed. And you can't.
But was that the intent of the document? That's why there's no deed.
But the intent of the document was not a deed, because the intent of the document was not to give her a present ownership interest. A deed gives somebody a present ownership interest. The parties, both Mr. Allen and Ms. RAHN, said, that's not what we intend. We don't want to give her a present ownership interest. She can't have one. It wasn't true that she couldn't have one. She didn't want to have one. She didn't want to have one because she didn't want to interfere with disability benefits from her son. Interestingly, by the way, the rationale for not having a present ownership interest, which Ms. RAHN concealed in violation of Chapter 184, Section 15B, and when you file a verified complaint and you're looking for a lis pendens, you cannot fail to disclose a material fact. A material fact here, a most material fact here, was why she was not taking an ownership interest. Because this whole case devolves into and onto one question. Was, by virtue of this instrument, did Ms. RAHN acquire an ownership interest in that time? There's no question Mr. Allen wanted to take care of her, wanted to take care of her down the road. You see all kinds of language like that. What you don't see is any language that comes close to any conveyancing language.
So what do you think the instrument was intended to do?
The instrument, at best, and I'll assume for the moment it was a binding contract, then what was intended was that down the road, Ms. RAHN would acquire an ownership interest in that property, or at least be treated as if she had one. But what was not intended was to give...
Hold on. With respect to what is intended, is that explicitly said?
Yes.
You think so? The down the road part?
Well, I take it that from the language that talks about an intention to provide, an intention to share, that's language that, to me, would suggest that there was a loving relationship between Mr. Allen and Ms. RAHN, and the question was an interest being conveyed to Ms. RAHN on that date in 1995? And that's the whole case, according to Ms. RAHN.
Could reasonable minds disagree as to what the as-if language meant?
I would suggest that reasonable minds would not disagree. As if is the subjunctive mood. As if is, because that's not so. If something is not, if I appeared here as if I were plaintiff's counsel, that would be contrary to fact. I'm here as defendant's counsel. But if you said to me, but Judge, I'm going to make this argument as if I was plaintiff's counsel. Right, but I'm not.
I know, but if you said that to me,
yes,
wouldn't I be able to look at you and say, okay, this isn't really his position, but he's making this argument as if he was plaintiff's counsel, and so therefore I'm going to hear it through those ears.
But he was going to, when you see this language that talks about as if this were a deed, jointly held property, that's to say that it is not a deed. And let me jump ahead, Judge, to the fact that there was a lawyer involved here, because curiously, in my view, the motion judge thought that cut in favor of Ms. RAHN. I suggest to you that that cuts very much in favor of Ms. Hay. There's a lawyer involved. She knows how to create a conveyance of real estate. In fact, she said so. When you look at the instrument, she talks about a joint deed with right of survivorship. She knew how to do that if that's what the parties wanted, and she was counsel, according to the complaint, to both of them. So she was there to do what the parties wanted. And what the parties didn't want was to convey that property at that time. Maybe down the road, but there's no...
Is that what they didn't want, or did they not want Ms. RAHN's name on a deed?
Well, I'm not sure that there's... I see immediately the difference between not wanting her name on the deed and not owning an ownership interest, but I will tell you this, that the only way you get an ownership interest is by way of a deed with your name on the deed. And when you consider, I also want to address very quickly, Judge, what the motion judge also thought was cut in a particular way against my client, that is the formalities of this document. The formalities of the document would be the same whether there were an agreement to be recorded or whether there would be a deed to be recorded because of the requirements of the Registry of Deeds. There has to be a formal signing and acknowledgement and so on and so forth. We're not suggesting here, we don't have to suggest, that there was not a contract.
All right, so let's assume for a moment that we agree with you that there was no conveyance here, it's not a deed, if the complaint is drafted in that way, it's properly dismissed. What if the complaint added a breach of contract claim?
If it had, we would say there can't be any recovery because of the statutes of limitation that would bar the contract claim. The contract claim, and we did address this in our brief, the breach of contract claim suffered from two statutes of limitations problems. The first is the claim would have been brought within the short statute of limitations 1 year from the date of death of Mr. Allen. He died in 2021. No claim was brought. Even if the contract under seal were a 20-year statute of limitations, when would a reasonable time be for that cause of action to arise? Certainly a year or two after the two had nothing to do with each other anymore in 1997. So even if you bring the time that the cause of action arose to the year 2000, 20 years goes by, in fact, 25 years went by before this action was brought.
But your position is that the complaint doesn't even reference breach of contract. It's based solely on the theory that this was a deed.
In particular, what I'm talking about is what was said by the plaintiff at the motion hearing when, as Judge Lang said, she expressly eschewed any right to recover based on a contract theory. I also asked the court to consider the language here, not just the language that I've already quoted about the inability to hold possession, but please look at all of the language of this document that was prepared, as I say, by an attorney. This wasn't a clumsy attempt to make a deed and fail. This was a sophisticated attempt to make an agreement that would hopefully be binding between the two parties. And from top to bottom, Judge, the document begins with the name agreement, not deed. At the top, at the bottom, the document is signed by both Mr. Allen and by Ms. RAHN. Deeds don't get signed by grantees. The title at this time was solely in the name of Mr. Allen. In fact, the parties, the lawyer who drew the document for the parties, specifically notes that it's vested in Mr. Allen. Why? Because the parties wanted the world to know that at that time in 1995, and after the document was signed in 1995, it was Mr. Allen, and only Mr. Allen, who was vested with the title, so as not to interfere with the disability benefits that Mr. Allen was just as interested in her having received them as Ms. RAHN was, because they were living together and they were presumably sharing income and sharing expenses. And everything in between, the title of this document and the signatory, all of that language, and I won't read it all, but I know you've already seen it, and when I ask you to look at it again, all of that language is consistent with what might happen in the future. How am I going to take care of Ms. RAHN? Mr. Allen wanted to take care of her, but neither one of them wanted her to be an owner because, and again, I emphasize, Ms. RAHN should have told in her verified complaint. She had two chances, by the way. There was a verified complaint and a first amended complaint. She was required to explain to the court and disclose to the court all of the material facts. And her not wanting to take title, not an inability to take title, but her not wanting to take title should have been disclosed. That was particularly relevant, and in my view is one of the many factors that, with all due respect to Judge Lang, caused him to get this wrong. And when you take a look at the bottom of page 5 and the top of page 6, what you're going to see is that Judge Lang, I suggest, sort of slipped into regular motion to dismiss mode.
We'll be sure to take a look. I see that's your time.
Thank you very much.
Thank you.
Good afternoon, Your Honors. May it please the Court, Sean Kahn for Patricia RAHN. Your Honors, noticeably absent from my brother's argument is the standard of review that this Court has to look at. It's a frivolous standard. It's not the regular motion to dismiss standard, and that's how Judge Lang made his decision. Clearly, by a cursory review of the agreement, this claim is not frivolous, Your Honors. The express language of the agreement is the purpose of this agreement is to provide Ms. RAHN 1/2 interest in the property. In consideration of her good and valuable consideration, which we know is between $60,000 and $80,000, it is the intention of the current owner, Richard Allen, to share the ownership of the real property equally with Patricia as if her name was affixed to title as joint tenants with right to survivorship. Just that language in of itself defeats a frivolous claim. The frivolous standard, as your honors know, 184 section 15C, it has to be devoid of any factual or legal basis.
If you're divorcing yourself from the contract claim, though, how does that establish your client's ownership at that time of the property?
So
if there's no contract
So
claim.
it's as my brother admits in his papers, you don't need the word deed in agreement. There is a plethora of case law that says it's the intent of the parties that control.
Don't you need words of conveyance?
Yeah, and I think what I just read.
Not just an intent, but actually words of
Sure,
conveyance.
well, the case law, and this is a unique case where I think all the parties agree of what the case law is. The case law is that it's the interpretation, the general intent to convey overrides any interest, right? What I just read, based on the frivolous standard, the purpose of this agreement and the intent of this agreement is to give her a 1/2 interest with rights of survivorship. Clearly, that's conveyancing language, and that's what all the case law says, Your Honors. It's the Ames case, it's the Kaufman line of cases, where they have a document that has language in it, but it may not be a tenancy by entirety, it may not be a tenancy by common, but it's a tenancy, a joint tenancy, because the parties intended. And all those cases say is, why would, like we have here, why would these parties go to a lawyer, right, to create a document that means nothing? Right, to create a document that where no parties have any rights?
Well, it
Clearly.
doesn't create nothing, though. It arguably creates a contract, which needs to be enforced within a certain period of time, right?
So even if it's a contractual, if it's a contract, I would argue, based again on the frivolous standard that we're looking at here, that it's a deed, like Judge Lang said, it's not a matter of he's not making a determination of the merits of the case, right? Just by looking at that strict lens.
Right.
But if it's statute of limitations, I would argue, Your Honor, that would begin to toll when the decedent passed away in 2020. This case was brought in 2025. So either if it's the 6-year statute of limitations.
Yeah, but there's no argument. But you disclaimed the contract argument, correct? So we're not considering that. Judge Lang didn't consider it.
Right, Judge Lang didn't consider it. I wasn't at
Right.
I wasn't the motion. I was not the.
So maybe
hearing
my
for that,
question was
but yes.
misleading. I didn't
Sure.
intend it to be.
Yeah.
But my question comes back to the fact that without the conveyance language, with the language that says there is an intent to transfer, and a statement that, correct or not, that Ms. RAHN cannot at that time hold title to the property.
Yeah.
Where is there room in that set of facts for there to be a conveyance at the time of execution?
I think what Judge Lang said, and which I agree with, is you look at the document as a whole, right? The four corners of the document as a whole. The part of the agreement or the contract or the deed that says she's unable to hold title. The next line, which Judge Lang says, is that the purpose of this agreement is to give her 1/2 interest, and based off the frivolous standard, that doesn't make it devoid of law or fact. That's what we ruled, and that's what
As a conveyance, you're saying?
Yeah, I mean, based off that frivolous standard, and that's what this court has to review, that strict lens. It's certainly not frivolous. I mean, I think clear evidence of that is how Ms. RAHN found out about this is a title company reached out to Ms. Hay and said, hey, there's an issue here of title. Clearly, if that title company thought that it was nothing, that it wasn't an issue, you know.
But that's not a determination by the title company that there is an ownership interest. That's the title company saying, let's get this off the table and so we don't have to worry about it, correct?
Sure, but based off the frivolous standard, clearly they didn't think it was frivolous, otherwise he wouldn't have asked for a release from Ms.
I'm sorry,
RAHN.
let me let you finish your answer.
Of course, I apologize, Your Honor.
Does that cut both ways, though? Because what did she do to exercise her ownership interest prior to being contacted by title, by Mr. Hay?
So I think the argument there is, and what we say in our brief is that because it was a deed by rights of survivorship, the second the decedent passed away, Ms. RAHN became owner. She didn't have to do anything. She became owner through that. You don't need to prove a claim because of how it's written with rights of survivorship, and that's in the agreement. The second the decedent passed away, she became full owner of the property. That's the claim.
Is she still living in the property?
She's not living in the property.
She's been out, right? She's been out for
yeah.
2 years after, or around the time that they separated?
Yeah.
And so, who's been living in the property for the last 20 years?
I believe the decedent was, and it was a tenuous breakup. There was abuse allegations, so they separated and lost contact. I don't
When
believe
did Mr. Allen pass?
When?
Yeah.
2020.
2020.
Yeah, 2020. So, again, if I'm ultimately, or Ms. RAHN is ultimately correct on this, and it's a deed by right to survivorship, the second the decedent, Richard Allen, passed away, she became the owner. There's nothing for her to do further. It was recorded on the Registry of Deeds, like Judge Lang said, gave world notice that she, when Mr. Allen passes away, becomes the owner. It says right to survivorship, as if deed, as if right to survivorship. Again, looking through the frivolous lens, which this court has to do, that's not frivolous, right?
So you'd agree then that if we determine this is not a deed, then the plaintiff is out of luck?
So, and I think the answer to that, Judge, is this court's not determining if it's a deed or not. This court's determining if the claim was frivolous or not. So the claim isn't frivolous. Ultimately, the merits of the case will be if it's a deed or not.
But if you can't, if the claim depends upon your ability to prove that this document is a deed, if we determine that it's not a deed, then doesn't that deprive you of your ability to prove your case?
So if you're saying that the case, that ultimately that the claim was frivolous and therefore it's not a deed, then yeah, ultimately, I think, so this is a declaratory judgment claim, right? I think we'd have to go through each line, because what my claim is saying that ultimately my client owns the property, right? So, but I don't think this court, based off that frivolous standard, is doing it. That's for later down the road on the actual merits of the claim to determine whether it's a deed or not.
Could I ask a question on the declaratory judgment? And I may be off in red herring land on this one, but my understanding is that you are seeking declaratory judgment that Ms. Hay was the sole owner of the property, correct?
Sure, yes, based
There's
off
no
that.
lesser claim of declaratory judgment of some interest in the property, is there?
This is how I would foresee it, is if it's determined that the right of survivorship language applies, then yes, she's the sole owner. If we get into whether or not the 4 unities apply, and Judge
Right.
Lang kind of got into this, then she would be a tenant by common. She will own half the property.
But that wasn't what you were seeking an answer. You were all in, all out, the way you pled it, right? She's either sole owner or she's not.
I have to go back and look, Your Honor, and I think the way the law would work is if a court determined it wasn't a right of survivorship, it doesn't say it's extinguished. The next step would be that it's a tenants by common, because the 4 unities are not there.
That I understand. I think my question was just whether once you have pleaded it a certain way, are you bound to the way it was pleaded? Or, as Judge Lang seems to have taken the view, some amendment of your pleading can be inferred to match up with whatever the surviving viable claim might be, or not frivolous claim might be.
Yeah, I think if it's pled in a way where we're saying that she owns it outright, and this court is likely to dismiss it, then yeah, I think we would seek to amend that potentially and add a contract claim. But again, I think the way it would work logistically step by step is if a court determined that it wasn't a right of survivorship, that she would still own half the property. I don't think you need to plead that. I think that's just by law that happens.
So I don't want to, discuss issues that may not be ripe yet, but I don't know that it's proper for you to disclaim in front of one judge that it's not a contract, lose on that argument, and then go amend and call it a contract. I'm not sure about the propriety of that, but we'll leave that for another day.
Certainly, and again, I think it's a matter of looking through that appreciably hard standard. That's what Judge Lang said, right? He's not determining whether or not I'm right, whether or not my brother's right. He's looking it through what that language says in that agreement, and he determined it's not frivolous. And that's certainly not an error of law. That's certainly not abuse of discretion. Happy to have any more questions, Your Honor? Or
Hearing none, matter stands submitted.
Rest of my brief, thank you.
That concludes our business for the day. Thank you all. Mr. Court Officer, our timekeeper. Court is in recess. All rise.